Brendan and Christine Banfield owned a beautiful home in a cul-de-sac in the leafy suburb of Herndon, Virginia. He was an armed IRS law enforcement agent, and she was a nurse. Together, they had a beautiful 4-year-old daughter, but they needed help with childcare. So the Banfields hired Juliana Magalhães, a Brazilian au pair, in October of 2021. By August of 2022, Brendan was sleeping with the au pair, sometimes in the marital home, sometimes when Christine was home. They also traveled together, Brendan and Juliana taking a New Year's trip to New York City and ringing in the new year together. Then in February of 2023, prosecutors say they conspired in a twisted plot. They allege the pair opened a bank account on a fetish website, pretending to be Christine. Then they catfished a man named Joseph Ryan and convinced him to come to the home early one morning to engage in a rape fantasy with a knife. In the midst of the rape fantasy, prosecutors say Brendan shot Joseph Ryan and then framed him for Christine's murder by stabbing her with his knife. The au pair has admitted her guilt and testified against Brendan. But now Brendan has chosen to take the stand in his own defense. We are live from Virginia with all the latest in the au pair affair murder trial.
All right. Good morning.
Good morning, Judge. How are you?
Good.
Morning.
I don't know how am I guess is the question.
I think we're good.
Okay.
Your Honor, the Commonwealth has elected to proceed on one count of aggravated within 3 years and one count of aggravated same transaction. We have presented one instruction for each of those counts. It is the model. We have added to that one instruction that had not been previously provided for child endangerment. We will not be going forward on.
And I'm going to take out the child abuse one.
Abuse and neglect, exactly.
Okay.
And then we have withdrawn, and I can tell you which letters,
Okay.
instructions
Right.
that were related to
Sure.
first degree, second degree.
Let me hold on a moment, just for the record. Which counts of the 4 counts of aggravated murder are you going forward on?
One moment.
Either 1 and 3 or 2 and 4. I think those are the options.
Right.
But I just want to make sure for the record.
Okay, good.
And I'm sure you're right, Judge, but we'll open it really quick and just
Okay.
make sure that
Absolutely.
our 1 and 3 and 2 and 4 are the same as yours.
One Joseph Ryan, 2 Christine Banfield, 3 is Joseph Ryan. Two.
Sure.
So,
So 1 and 3?
1 and, no,
No,
1 and 4.
1 and 4.
1 and 4?
1 and 4.
Okay.
So-
Absolutely. That's fine. Any objection to that then?
No, Your Honor.
All right, so we're going forward on count 1 and 4 of the case number ending in 666. And then for 2 and 3, there's a motion to dismiss
dismiss.
those.
Oh, wait,
so you have
okay,
no
hold on, I'm
objection to-
getting
I'm sorry.
tapped.
No, ma'am.
Wait a minute, hold on. There seems to be a change here.
Sorry, we're gonna read this one more time.
Same after transaction.
Yep,
1,
1.
right, 4. Same 3-year period, Christine. Yes, 1 and 4. Dismiss,
Oh, you're-
2 and 3.
Okay,
Yes,
final answer?
yes.
Okay, 1 and 4. So we're dismissing 2 and 3 with no objection.
No
Okay,
objection.
all right. So 1, 4, and 5 under the case number 666. And then we just have child endangerment on
Which
the
is,
one ending in 873.
that's
Okay,
count 1, Judge?
that is count 1.
Yes.
So count 2 is dismissed
Yes, ma'am.
on that, on 873. Okay, fabulous. So now I have the ones before that we had talked about. Do you just want to go through those?
Yes, ma'am.
Okay,
And I will pass up our new stack. They're clean. They have the
Okay,
letters typed
excellent.
in.
all right, so I had in, instruction A, which I assume is still the same, correct?
Yes, ma'am.
Okay, and then we'll withdraw instruction B since he did
Correct.
testify. Okay, withdrawn. And then you still have C,
Yes.
okay. D,
Yes.
E,
Yes.
F,
Yes.
G,
If they stop sticking together, yes.
all right, and then H.
Judge, I have an I next.
Oh, I'm sorry, H is child abuse, so you're throwing
Yep,
that
so
one.
that would be withdrawn.
Okay, fabulous. All right, and then we have I,
Yes.
okay. Q,
So Judge Q would be withdrawn.
Q is withdrawn, I assume without objection.
Without objection.
Okay, Q is withdrawn. Okay, what do you have next? R?
I actually had an L.
Okay, you had L. I switched them around a little bit because.
That's okay because they didn't make sense in that order. That's fine.
Well, not to me, but.
Nope,
maybe.
that's A-okay. I can track.
I could,
So
that's fine. I'll just.
if you're on R next, we would withdraw R.
Withdraw R, okay.
We would withdraw S.
I have M next.
Okay,
M
so
as in Mike.
M is in.
Okay. S as in Sam,
S as in Sam would be withdrawn.
okay. N as in Nancy,
Yes,
O,
yes,
P,
yes,
T as in Tango,
yes.
okay. And then I think, let me see, then I have some of his instructions. I think that's all I had for you. So which one would you like to add to that?
So I have L, which was willful.
Willful, okay, you have L.
I do.
All right, do you have a copy?
I
Well,
do.
You got the clean copies,
Yep,
that's
I'm
fine.
going to
Okay,
pass that
so
up to your honor.
we'll add L, okay, and what else?
And then I have U, which is the instruction for aggravated murder 3-year period.
Okay,
And then I have V, which is the instruction aggravated murder, same actor transaction.
okay.
And then I have X, which is the crime of child endangerment.
Okay. And your U and B have the waterfalls also?
They do not, Judge.
You're not doing
We are not
waterfalls?
doing a waterfall.
You are just standing on aggravated murder?
We are.
Okay, that is your option. Do you want waterfall instructions, Mr. Carroll?
No, Your Honor.
No.
I stand on as well.
Okay, so we're standing on aggravated murder. You've just made life a lot simpler for me on your decisions, but that is your decision. Okay, so no waterfalls, we're standing on aggravated murder.
Yes, and I'm passing them up with the previously agreed upon new separate so that you can put them in
Okay.
as you
Okay.
would like them to appear.
All right,
I also understand we've agreed to defense 2, 4, 10, 12, 16, 20, and 36.
I think that's what I have.
No
Let me make
changes.
Sure. Those are the only ones I had already had, correct?
Correct.
Yes, Your Honor.
I have 2, oh, I do have L, okay, sorry. I do have 2, 4, 10, 12, and 16, and 20, and 36.
Yes, ma'am.
Okay, anything to add to those, or that's it?
No, Your Honor.
Oh, you guys get a gold star today.
Thank you.
Okay, that is fabulous. All right, so you want to hand me up you have the clean copies for your, oh, you already gave them.
Yep.
Okay, I got the clean copies. And do those include Mr. Carroll's, or Mr. Carroll, yours were already clean copied, correct?
The ones that I handed up before were clean copies.
Okay, so I can just insert his into
Yes, ma'am.
yours. Perfect.
And
I
at this
can do
point,
that.
we owe you a verdict form. Now that you have accepted those
Right, yes,
instructions.
I have those instructions.
We will provide you with a verdict form.
Okay, oh, that's fine. So if you want to provide a verdict form, I can have Shannon do one since it's just aggravated murder now. It's not too difficult.
If
I can do that.
that's just fine.
So we'll do 3 verdict forms, one for aggravated murder, one for firearm, and one for child endangerment.
Yes,
We're on
ma'am.
the same sheet, music? Okay, good. 3 verdict forms?
Ms. Fritzler is asking, do you think we need 2 aggravated murder forms?
Oh, yes,
given
I'm
that
sorry.
there are
I
2 separate?
apologize. You're right, because you did go ahead and do both, same occurrence and 3
And
years.
3
Yes, so we need 4 verdict forms. Aggravated murder in the same act and transaction, aggravated murder in 3 years, firearm, use of firearm, and child endangerment. Okay, we'll get those together.
Perfect, thank you.
And by the end of closings, we'll be able, you can review them before they go back to the jury.
Great, thank you.
Okay,
Your Honor,
Yes,
is
sir.
there an order that you're going to be calling out the jury instructions?
there is. Let me just put it back into the
Okay.
order and I will let you know. And I will actually get copies to you as well.
Okay.
In the order that I'm going to give them, and I'll get one for the court reporter too,
Oh,
Carol.
Great, thank you.
So I'll do that. We'll have time to do that, okay?
Okay.
So that takes care of jury instructions. Do I have Ms. Smith here yet? Ms. Smith, are you here? Are you ready for your motion?
Yes.
let's go. Is that okay?
Yes,
I'd
absolutely.
rather do that than I can go back and put those instructions all
Yes,
in
ma'am.
order. Ms. Smith, you can just come to the center podium, that's fine. Apologize, these were always wrong.
Just want to make sure I have the right Miss Smith. This is for the access motion?
Yeah, yes.
Okay, great.
Well, you're Ms. Smith, so.
Well, no, I know. I just,
answered.
there could be multiple Miss Smiths, so I wanted to make
Well,
sure.
the odds were pretty good that I had the right person. I know it was set for 9:30, but since we were so organized today, if it's okay with you, I'd like to go ahead and do it now.
Absolutely.
All right, I've read your motion,
Thank you.
so you don't need to regurgitate it, but anything you want to add to the record, you're welcome to.
Oh, thank you. No, I mean, I appreciate you reading it. And just for the record, I'm Alia Smith here on behalf of ABC and NBC for access to sealed records. And I won't repeat what's in our papers, other than to say I read the Commonwealth's opposition yesterday.
Right.
And, I don't think that they offered, the compelling reasons that are necessary to seal, in a public criminal trial. The fact that the litigation was concluded in the Daily Press case, which is one of the main authorities that we relied on, I don't think is a distinction, because the harm that they're claiming here is not to do with jury tampering or jury impact. And same with they try and distinguish the press enterprises cases, because in the press enterprise cases, the Supreme Court was dealing with the sealing of a whole entire trial.
Being closed, correct.
Correct. And that's true. And I appreciate very much that most of this trial has been completely open.
400 exhibits and televised. So.
Exactly. And the exhibits available on the internet. But I think the point of the press enterprise and Globe newspapers and all the Supreme Court cases is that, every aspect of a criminal trial needs to be open. And if it's not, the sealing has to be justified by on-the-record findings of a compelling interest, and I don't think that's been done here.
Okay, all right, thank you, ma'am. Did you want to respond? I did read your opposition
We
brief.
would submit on our brief.
Spin on your brief. Did you want us to respond, Mr. Kerr? You joined your microphone, just.
Your Honor, I would join in the Commonwealth's position.
All right, thank you. Okay, you can stay right there. That's fine. All right, so the ruling on the media motion, non-parties ABC and Dateline have moved to unseal certain exhibits admitted during this trial. The court fully recognizes and respects the First Amendment and the fundamental principles of transparency in our judicial system. These proceedings have at all times been open to the public and the media has not been denied access to any hearing or trial testimony in this case. At the same time, the court does not take the sealing of documents lightly. When considering sealing or unsealing, the court must balance the public's right of access against other compelling constitutional and statutory interests. Here, the constitutional and statutory rights of crime victims. Article 1, Section 8 of the Virginia Constitution, entitled Rights of Victims of Crimes, and Code 19.2-11.01, entitled Crime Victim and Witness Rights, require that crime victims be treated with dignity, respect, and sensitivity, and that their privacy be protected to the extent permissible under law. Victims are defined in relevant part to include family members of homicide victims, including spouses, parents, children, and siblings. As the Supreme Court recognized in Globe Newspaper Company versus Superior Court, the First Amendment right of access to criminal trials serves the important purpose of protecting the free discussion of governmental affairs. However, that right is not absolute. It may be limited where there is a compelling governmental interest, and any limitation must be narrowly tailored to serve that interest. The court finds that unsealing these materials would add little, if anything, to the public's understanding of the judicial process, while substantially infringing upon victims' constitutional and statutory rights. Here, the court finds that the protection of victims' rights constitutes a compelling governmental interest. That interest necessarily limits the public dissemination of graphic depictions of deceased victims, nude victims undergoing life-saving measures, and autopsy images, particularly where such materials would be available for permanent public distribution, download, and reproduction worldwide. The First Amendment does not require the court to permit the exploitation of crime victims or their families by releasing graphic images of their loved ones' bodies for purposes unrelated to public oversight of the judicial process. The victims in this case were a mother, daughter, sister, and a son, brother, and grandson. Their surviving family members' constitutional rights must be considered and respected. This remains a public trial. Of the exhibits admitted into evidence, approximately 400 exhibits are unsealed and publicly accessible on the court's website 24 hours a day. 74 exhibits were placed under seal. The court has reviewed each sealed exhibit admitted in this case to ensure that sealing was narrowly tailored and justified. I will note initially that one category of material referenced in the motion, the co-defendant's interviews with the Commonwealth, were never admitted into evidence and are not part of the court's record in this trial or any pretrial proceeding, okay? Those materials remain in the possession of the parties and are not subject to unsealing by the court. Additionally, the minor child's interview was sealed pursuant to a pretrial motion due to the presence of a minor victim, and that sealing remains appropriate. With respect to the sealed body-worn camera recordings, the moving parties requested that the court redact or excise portions depicting victims' bodies and release the remainder. The court received these exhibits in their entirety as evidence. It is not within the court's role or technical ability to edit, splice, or alter admitted evidence, and the exhibits must be considered as they are entered into the record. All sealed exhibits were sealed pursuant to motions agreed to by the parties at the time of admission. For the record, the court will now go through each sealed exhibit and state the basis for sealing. In doing so, the court does find that certain sealed exhibits do not implicate victims' rights and therefore will be unsealed. Okay, so I'm going to go through it. And I'll give you a copy of this.
No, I appreciate that. And can I just be heard on for one moment on the body-worn camera footage?
You can, but I'm not going to change my mind. Okay. All right. So would you not rather do? Okay, good. Okay. So let's go through the sealed exhibits. All right. Number 4 is a body cam of Officer Hugh. Both victims are shown. One is deceased and one is nude, and life-saving measures are being taken. A recently sealed number 5 is a picture in the far right corner. You can see Mr. Ryan's body. Number 6 of the Commonwealth's evidence, body cam of Officer Beckner. Both victims are shown. One is deceased and one is nude, and life-saving measures are being taken. Number 8 is a photo from the still body cam, and it's of the victim's body. Number 9 is also a photo from the body cam of the victim's body. Number 10, the body cam of Officer Gibbons. Both victims are shown. One is deceased and one is nude, and life-saving measures are being taken. Commonwealth's Exhibit 11, the autopsy report will be unsealed. Commonwealth's Exhibit 12, the autopsy report of Mr. Ryan will be unsealed. Number 11 was Ms. Banfield. Number 13 is a photo of Joseph Ryan's deceased. Number 15 is a photo of Joseph Ryan deceased. Number 20 is a photo of Joseph Ryan deceased. 22 is a photo of an autopsy of Ms. Banfield. 23, 24, 25, 27, 28, 29, 30, 31, 32, and 33, and 34, 35, 36, 37, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, and 49 are all photos of the autopsy of Ms. Banfield. Number 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, and 71, and 72 are all FetLife conversations which will be unsealed. Number 98 is a photo aerial view of the house, but Mr. Ryan's body is in the photo. Number 9, a photo of Mr. Ryan's body on the floor. 100 is a photo of closer up of Mr. Ryan's body on the floor. 101 is also Mr. Ryan's body. 101A is that same photo with annotations. 101B is the same photo with annotations. 123 is a photo of Joseph Ryan's body. 123A is the same picture with annotations. 123B is the same picture with annotations. 124 is also a photo of Joseph Ryan's body. 170A is a photo of 171 with annotations, which is a picture of Joseph Ryan on the floor, deceased. 172 is a photo of Joseph Ryan's as well on the floor. 174A is that same photo with annotations. 181 is a photo of Joseph Ryan's body. 221 photo is a Joseph Ryan's body. 221A is the same photo with annotations. 241 is a photo of the body-worn camera, a still photo with the victim, Mr. Ryan, on the carpet at the crime scene. As far as defense sealed exhibits, the body cam video of Officer Palmer has the body of both Joseph Ryan and life-saving measures being taken from Ms. Banfield at the crime scene. And number 87 is a body cam video of Officer Casanova without audio, and the minor child victim is present for a significant portion of the video. And 119 is a Gmail log for FetLife, which I will unseal. So I will give you a copy of those, and I'll highlight the ones that I'm unsealing. They're already highlighted.
I appreciate that very much. And just for the record, I'd like to add that in the Noor case that we cited,
Sure.
The court did order the availability of redacted video and documentary records. And in the AP case from the Fourth Circuit, the court held that administrative burdens are not a sufficient compelling reason to keep things. And so I really feel like, there's a way that public can have access to some of this, even if they don't have the specific, very graphic
And
images.
the exhibit is the exhibit, and I take the exhibit as it is. All right, thank you very
Understood.
much for
Thank
your
you, Your
motion,
Honor.
and have a good day, Ms. Smith. All right, do we have anything then until 10 o'clock?
No, ma'am.
All right, I will go ahead and get the instructions put together in the order I'm going to do them, get a copy of them, and if you want to stay here, I'll get you the copies so you can be prepared for your opening statements, okay?
Thank you.
All right, thank you. All rise.
of some of what Brendan Banfield said yesterday. Obviously, he testified 2 days, but we do have a little bit of a summary video for you of Brendan's testimony from day 2 of his testimony, if we're able to take a listen to that.
I heard the sounds of, I would say, moaning, as well as sound of skin-on-skin contact.
What did you think was going on?
Sex.
Why didn't you call 911 at that point?
Well, I believe that it was an affair. I thought about just ignoring the situation and going to work. The sound, I guess, sounded like it changed to me. Instead of what I thought was the sounds of sex, I thought that the impact sounded forceful, and that Christine's moaning sounded painful and not pleasurable.
Walked up the stairs with the gun out. Is that accurate?
Yes.
Okay. And when you turned and saw Juliana had followed you, at that point in time, you're worried that bad things are happening, correct?
Yes, I am.
Did you tell her to call 911 at that point?
No, I was moving quickly towards the door.
Did you tell her to go back downstairs and get your daughter out of the house at that point?
I wasn't worried about Juliana at that point. I was worried about Christine.
Okay, and you weren't worried about your daughter at that point either then, right?
I don't think it was on the top of my mind when I believed that Christine is being injured, and that was at the forefront of my mind. I don't know why she chose to come to the house.
Okay, but you're law enforcement.
They've been given this no waterfall instruction. And what that means is the jury cannot decide that Brendan Banfield is guilty of killing just Christine or just Joseph. It is either he killed both or he did not kill them.
Okay, very important.
Mhm.
Also important, you may have been logged on to our streaming a little early, whether it was YouTube or WUSA 9+, and you've been watching sort of the courtroom proceedings getting underway at 9 a.m. before the closing arguments. And that was between all parties involved, kind of going over some housekeeping things, if you will. Do you want to explain a little more about that?
Yeah, so they were going over the charges first, but then they were also going over this media motion, if you will. So some news outlets, agencies had requested some of the body camera footage, some of the autopsy reports be unsealed, if you will, and that would give access to the media to see certain things. And the clips they wanted unsealed, these specific media agencies, were clips that were graphic, you know,
Very sensitive material.
very sensitive information and material and video of very disturbing things happening. And, you know, one of them, I believe, was the interview with the little girl, which, as you know, was not submitted as evidence. So the judge denied all of that.
Yeah, and she was 4 years old at the time that this occurred.
She's now 8.
Right. And we know, though, the autopsy reports of both victims will be shared, right? Also, the FetLife conversations. FetLife was the website in question here, the fetish website where they the prosecutor claimed that, you know, they conversed with Joseph Ryan and lured him to the home. The Gmail log of FetLife will also be released. So those were some of the things that they were taking care of before closing arguments get underway at 10 a.m. Yesterday, a very emotional day for the families involved. Christine's parents, Brendan's parents, Joseph Ryan's family watching this, and Brendan on day 2 describing the final moments of their lives.
Yeah, and we do have a kind of a highlights reel of some of what Brendan Banfield said yesterday. Obviously, he testified 2 days, but we do have a little bit of a summary video for you of Brendan's testimony from day 2 of his testimony, if we're able to take a listen to that.
I heard the sounds of, I would say, moaning, as well as sound of skin-on-skin contact.
What did you think was going on at that point?
Sex.
Why didn't you call 911 at that point?
Well, I believe that it was an affair. I thought about just ignoring the situation and going to work. The sound, I guess, sounded like it changed to me. Instead of what I thought was the sounds of sex. I thought that the impact sounded forceful, and that Christine's moaning sounded painful and not pleasurable.
Walked up the stairs with the gun out. Is that accurate?
Yes,
Okay. And when you turned and saw Juliana had followed you, at that point in time, you're worried that bad things are happening, correct?
yes, I am.
Did you tell her to call 911 at that point?
No, I was moving quickly towards the door.
Did you tell her to go back downstairs and get your daughter out of the house at that point?
I wasn't worried about Juliana at that point. I was worried about Christine.
Okay, and you weren't worried about your daughter at that point either then, right?
I don't think it was on the top of my mind when I believed that Christine is being injured. And that was at the forefront of my mind. I don't know why she chose to come to the house.
Okay, but you're law enforcement and this is your house. You're not going to tell them what to do to ensure that they are safe when you have this doubt about what's going on?
I understand that. And it may have been a mistake that I didn't send them back out. And it's something that I've thought about many times. Christine was, I would describe as nude and on all fours. And Joe Ryan was behind her. He was clothed. He was looking directly at me. I had never seen Joseph Ryan before.
Have you ever had any communications with him before?
On February 24th is the only time I had communications with him in that room. I did not want to shoot him. He did a very forceful stab towards Christine. Christine told me that she was bleeding out and that she was sorry and that she loved me. He was stabbing her. I mean, I wish I shot him earlier.
Now that you've heard all of the evidence, every possible hearing that could happen in this case has happened. Now you are ready to tell us what happened. Is that accurate?
I was ready to tell what happened at Juliana's testimony, at Juliana's trial when that was scheduled for November.
These very strong feelings, these let's be together for the rest of our lives feelings did not exist when your wife was alive.
Correct. Juliana and I weren't even together when Christine died.
You had broken up, is that correct?
Yes,
Okay. Did you need to kill your wife to get her back?
definitely not.
One of those affairs was with a woman named Danielle, who you met on a fetish site searching for sugar babies. Is that correct?
I would not call it a fetish site.
Okay. What would you call it?
An arranged relationship.
Okay. But you were looking for someone to be your sugar baby?
I guess. It was a relationship where they would already know that I was married.
From him, and that was day 2 of the testimony. Day 1, he kind of talked about the moments prior to the day of February 24th, 2023, but that was his recap of that day.
Yes. So we learned more about his relationship with Juliana, the 911. You heard Jenna Sands, the prosecutor, asking him, why didn't you call 911 right away? Also, she did ask him about, you had 3 years to share this story about you saving your wife's, trying to save your wife's life. Why now? And, it did seem like, to me, he had answers for everything.
He did. And I will mention something that Frank Salvedo, our criminal defense attorney.
Now, whether they were, it's his claims. What I'm saying that as she was peppering him with questions, he seemed to have a response.
Yeah. And, one thing to mention here, Frank Salvedo, our legal expert who was with us yesterday, he commented on, he kind of raised a red flag on that line of questioning because Brendan has the right to stay silent. He does not have to give his story.
Sure.
He had an attorney at that point, and
he did say he was instructed by his attorney.
Right. And so Frank pointed out that that was a risky line of questioning for the defense attorney, and by the prosecutor, Jenna Sands, and we did hear defense attorney John Carroll object to it. And then we saw them all go up to the bench, and Frank explained that John Carroll is likely flagging that moment for the judge because it was overruled. So the judge said, Jenna Sands, you can continue this line of questioning. And Frank said he thinks that was flagged by John Carroll as a possible opportunity to appeal if Brendan Banfield is convicted, because she's questioning his right to remain silent.
That's right. We also got a little bit more about this relationship that he had with Juliana, the au pair.
Mm-hmm.
Initially on day one, he testified that this was nothing serious. It was just a fling that we had. And Jenna presented then with letters that Brendan had written to Juliana as she was in prison, professing his love for her, and also going as far as, talking about possible baby names, for the future. I think that was a big moment out of the courtroom yesterday. Also, he admitted that, or he claimed that he had no idea Juliana had gone to his gun safe to retrieve his personal gun.
Yeah, and you know what was interesting there? We heard, as expected, Jenna Sands say, why did she have the code to your safe? And it wasn't really clear why she did. He said she was sitting next to him when he opened it one day. He also mentioned it was the same code for their door. But again, why did your au pair have the code to your safe that you held your gun in? And she pointed out, you're a federal law enforcement agent. Do you normally allow anyone to have access to your gun safe? And then obviously came up the question of, why'd you bring your au pair to a shooting range to go shooting? And again, he had an answer for everything, right? We saw that. He mentioned it was just an activity for them to do.
A lot of big moments coming out of yesterday. I understand we also have a highlighted moment when so going into yesterday, we talked about this, right? That we ended day one with Brendan testifying that this day, the morning of February 24th, was a big day for him as a former federal agent, at the time our IRS agent. He had this big operation that he had to do. It really weighed a lot on his promotion to become a senior special agent. And he really beefed it up to be a moment where he had to be there.
Right.
And he got up earlier and started his day so that he could get ahead and go to the conference room and things like that.
Yeah. And a little bit of context to add more to it, as I listened back to it last night, and the night before was his birthday. He was actually supposed to go to New York to celebrate with some friends, and he canceled those plans. And the prosecutor was questioning, why'd you cancel your plans? You're claiming you didn't know your wife had off work the next day until the night before. And he said, I had this really big, important meeting. And then yesterday we see the hearing start. We're expecting more testimony from Brendan Banfield, but first Jenna Sands gets up there and she says, hey, we have this new witness who came to us.
The state asking to bring on a rebuttal witness because this person, after watching Brendan testify on day one, said, wait a minute, I have specific information here that could counter what Brendan is saying on the stand. And so they brought that person in, and that person was the former, T. Patrick Smith, and he was Brendan's former supervisor, former boss, and he just dropped a bombshell.
Yeah, let's take a listen to that clip if we can. It's the moment of Brendan's testimony, but then that rebuttal witness kind of coming up there as well.
The day was an important day for me at work as well. There was an important meeting for one of my cases. There was going to be a undercover operation for one of my cases. And we were meeting with the undercover officer, a senior special agent, and my manager. And that meeting was scheduled for 9:30 that day. This was a particularly important meeting for me, as had been indicated that success in this case may lead to me getting a promotion to a senior special agent.
We are requesting permission to add an individual to our witness list. We're approached by a witness who indicated that they had specific information that was contrary to something the defendant testified to. This is a surprise to the Commonwealth. To your knowledge, was there a meeting scheduled between yourself or with Juliet and Mr. Banfield on the morning of February 24th, 2023?
Leading.
Sure.
Sustain the objection.
Did you have any plans for the morning of February 24th, 2023?
I did. I was in Baltimore on an unrelated undercover operation on that morning.
Were you scheduled to meet with Mr. Banfield?
I was not.
And again, I'm sorry, where was Juliet, his other supervisor?
She was out of the country.
All right, so a really powerful moment there. We'll see if it had an impact, but let's get back into what's happening today, right? We're going to hear closing arguments from the prosecution and the defense really any moment now.
Yes, they will be basically tying this up, and we don't know how long this could take. I mean, it could take an hour, it could take longer. But keep in mind, they do like to break for 15 minutes. So somewhere around 11:15 has been sort of the typical time. And then we break again for lunch at 1, and that's about an hour long, and court will resume. So we are just moments away from closing arguments where the defense and prosecution will wrap this up for the jury members. And speaking of the jury, I mean, they have really been through a roller coaster the past 3 weeks. We anticipated this going into 4
Possibly
weeks or
next
so,
week,
which
right.
is possible if we don't get a verdict today. But just like you, I mean, we have been watching every moment of this,
Right.
and it started off as a complex and layered case, but boy, I did not anticipate some of the twists and turns that we saw.
A lot to see, and we'll have a lot more coming up at 11:15. We're going to take you through what we just watched, what you can expect throughout. We will have Frank Salvato here with us during the lunch break, so if you do have questions for him, you can start dropping them in the chat on YouTube, or feel free to text us. The number to text is 202-895-5599. Again, that number is 202-895-5599. But really, we are just moments away from the start of closing arguments. I know she's been very prompt. Judge Penny Ascarati has been very prompt. I'm curious to see how quickly they're going to get through these closing arguments. Remember, opening statements were less than 40 minutes with both of them going.
Yeah, opening statements didn't take long. And also, taking us back to that time, opening statements didn't take long. And also, we had such an aggressive start. We didn't expect or think that Juliana would actually take the stand that first day.
Yeah, the first day of hearing from both the prosecution and the defense, we got through 5 witnesses that day, and then Juliana, the supposed star witness to the prosecution's case. So I think we'll continue to see Jenna Sands push through and be quick. I'm more curious if John Carroll is going to take his time here with this. Does he want the jury to have the whole weekend to think about this, or does he want them to kind of want to be done with this and get done by the end of the day? It is a Friday. We're going into the weekend. And remember, they weren't supposed to have court on Fridays. They have had court this Friday and last Friday because of the snow. But they weren't supposed to be in court on Fridays.
That's right. Okay, so we will be watching that closely. Again, I don't know if we have that number slate for our viewers here, but that number again is 202-895-5599. I know you all have been sharing a lot of your comments and questions with us, and we've been asking Frank with that. Yesterday was a very, very active day. Many of you weighing in on day 2 of Brendan Banfield's testimony because there were so many things that came out of the courtroom yesterday.
Yeah, and if you at home want to weigh in and let us know, we'd love to hear what you think of the case. We're trying to read as many comments as we can, as many texts. Definitely text us your questions, but if you just want to weigh in, we're happy to kind of chat with you, Annie and I here. And hear your thoughts on everything that has unfolded. And we understand it is a lot. There has been a lot. You can only imagine what these jurors are trying to navigate as they make a decision that really is going to have a huge impact. It does look like court is about to start. We see Brendan Banfield sitting down there in the chair. So let's take you inside the courtroom.
That you wanted to put the two together, which if you want to take a look at it, if you want to approach.
Yes, ma'am.
You wanted to add 20, but you had 2 20s. So we combined them, Shannon combined them for you. Does that?
Yeah.
And there's no objection to 20?
No, ma'am.
All right. So what we'll do, no problem. So what we'll do, this is the order. I'm going to read them in for the record, and we have copies for the attorneys and for the court reporter for right now. Then we'll get copies for the jurors as well. All right, so the jury instructions we read, instruction A, C, D, E, U, V as in Victor, L, I, M, F, G, X, N, O P T 2, 4, 10, 12, 16, 36, and 20. Okay? All right. Is there anything else before we bring the jury out?
No, ma'am.
Okay.
Okay. I think this thing's on.
Good morning, ladies and gentlemen. I swear, juror number 2, I'm going to have to put you on the payroll. You keep that door open every time you come back. I really appreciate it. All right, ladies and gentlemen of the jury, you now have heard all the evidence in this case. All right, before the lawyers make their closing arguments, the court will give you the instructions of the law that you are to apply in deciding this case. Since it's been quite a while since I gave you the preliminary instructions, I want to remind you that in their closing arguments, the lawyers will refer to the testimony and other evidence that you will have heard, but what the lawyers say in their closing arguments is not itself evidence. Their statements are only their recollection of what the evidence in the case was. It is your collective recollection as 12 jurors of what the evidence in this case was, which shall govern your deliberations. In addition, remember your notes should be used only as an aid to your memory. You should not give your notes precedence over your independent recollection of the evidence, and you should rely on your independent recollection of what the evidence in the case was, and you should not be unduly influenced by the notes of other jurors. In addition, a reminder that the court has sealed the names of the jurors for a year. Just wanted to make sure I remind you of that. Okay, as far as the jury instructions are involved, you'll be able to take these written jury instructions into the jury room with you, and we'll make copies for all 12 jurors, okay? So you don't need to take notes on them right now, but I would ask for your attention when I read them, okay? With respect to the instructions I'm about to give, you might notice that at the top of them, some of them are numbered and some of them are lettered. You not have to concern yourself with that. You're just looking at the body of the instruction themselves, okay? Some of the instructions may appear to be in conflict. This is because the court cannot predict your findings of fact. Therefore, the court must instruct you, the jury, on the applicable law under both the Commonwealth's case and the defendant's theory of the case, okay? Brendan Banfield is presumed to be innocent. You should not assume that he is guilty because he has been charged and is on trial. This presumption of innocence remains with him throughout the trial and is enough to require you to find him not guilty unless and until the Commonwealth proves each and every element of the crime beyond a reasonable doubt. This does not require proof beyond all possible doubt, nor is the Commonwealth required to disprove every conceivable circumstance of innocence. However, suspicion or probability of guilt is not enough for conviction. There is no burden on Brendan Banfield to produce any evidence. A reasonable doubt is a doubt based on your sound judgment after a full and impartial consideration of all the evidence in the case. Any fact that may be proved by direct evidence may also be proved by circumstantial evidence. That is, you may draw all reasonable conclusions from the evidence. You may convict Brendan Banfield on circumstantial evidence alone, or on circumstantial evidence combined with other evidence if you believe from all the evidence that he is guilty beyond a reasonable doubt. When the Commonwealth relies upon circumstantial evidence, the circumstances proved must be consistent with guilt and inconsistent with innocence. It is not sufficient that the circumstances proved create a suspicion of guilt, however strong, or even a probability of guilt. The evidence as a whole must exclude every reasonable theory of innocence. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. You may consider the appearance and manner of the witnesses on the stand, their intelligence, their opportunity for knowing the truth and for having observed the things about which they testified, their interest in the outcome of the case, their bias, and if any has been shown, their prior inconsistent statements, or whether they have knowingly testified untruthfully as to any material fact in the case. You may not arbitrarily disregard believable testimony of a witness. However, after you've considered all the evidence in the case, then you may accept or discard all or part of the testimony of a witness as you think proper. You are entitled to use your common sense in judging any testimony. From these things and all the other circumstances of the case, you may decide which witnesses are more believable and weigh their testimony accordingly. If you believe from the evidence that a witness other than Brendan Banfield previously made a statement inconsistent with his testimony at this trial, the only purpose for which that statement may be considered by you is for its bearing on the witness's credibility. It is not evidence that what the witness previously said is true. The defendant is charged with a crime of aggravated murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that the defendant killed Christine Banfield and Joseph Ryan. And number two, that the killings were willful, deliberate, and premeditated. And number three, that the killings occurred within a 3-year period. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime is charged, then you shall find the defendant guilty of the aggravated murder of Christine Banfield and Joseph Ryan. If you find that the Commonwealth has failed to prove beyond a reasonable doubt any of the elements of the crime, then you shall find the defendant not guilty. The defendant is charged with the crime of aggravated murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that the defendant killed Christine Banfield and Joseph Ryan. And number two, that the killings were willful, deliberate, and premeditated. And number three, that the killings occurred as part of the same act or transaction. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime as charged, then you shall find the defendant guilty of the aggravated murder of Christine Banfield and Joseph Ryan. If you find that the Commonwealth has failed to prove beyond a reasonable doubt any of the elements of the crime, then you shall find the defendant not guilty. Willful, deliberate, and premeditated means a specific intent to kill adopted at some time before the killing, but which need not exist for any particular length of time. A willful act is one done with a bad purpose or without justifiable excuse, or without ground for believing it is lawful. A willful act is intentional or knowing or voluntary as distinguished from accidental. The terms bad purpose or without justifiable excuse require knowledge that the particular conduct will likely result in injury or illegality. To prove the charge of murder, the Commonwealth does not have to prove a motive for the killing. The presence or absence of a motive may be considered in arriving at your verdict. Brendan Banfield is charged with the crime of using a firearm while committing or attempting to commit murder. The Commonwealth must prove beyond a reasonable doubt each of the following elements of that crime. Number one, that Brendan Banfield used a firearm. And number two, that the use occurred while Brendan Banfield was committing or attempting to commit murder. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt each of the above elements of the crime as charged, then you shall find Brendan Banfield guilty. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either or both of the elements of the crime, then you shall find Brendan Banfield not guilty. A firearm is any instrument that is capable of expelling a projectile by force or gunpowder. A firearm is also an object that is not capable of expelling a projectile by force or gunpowder, but gives the appearance of being able to do so. The existence of a firearm may be proved by circumstantial evidence, direct evidence, or both. Brendan Banfield is charged with the crime of child endangerment. The Commonwealth must prove beyond a reasonable doubt the following elements of that crime. Number one, that Brendan Banfield had custody of Valerie Banfield, who was a child under the age of 18. And number two, that he willfully or negligently caused or permitted the life of such child to be endangered. If you find from the evidence that the Commonwealth has proved beyond a reasonable doubt both of the above elements of the crime as charged, then you shall find Brendan Banfield guilty of child endangerment. If you find that the Commonwealth has failed to prove beyond a reasonable doubt either or both of the elements of the crime, then you shall find Brendan Banfield not guilty. The fact that Brendan Banfield has been indicted by a grand jury is not evidence against him, and you should not consider it. If there is concert of action with the resulting crime, one of its incidental probable consequences, then whether such crime was originally contemplated or not, all who participated in any way in bringing it about are equally answerable and bound by the acts of every other person connected with the consummation of such resulting crime. You must not consider any matter that was rejected or stricken by the court. It is not evidence and should be discarded. You may infer that every person intends the natural and probable consequences of his acts. The Commonwealth bears the burden of proving beyond a reasonable doubt the identity of the defendant as the person who committed the crimes charged. If the Commonwealth has not met this burden, you must find the defendant not guilty. You may consider the character of the defendant when proven by the evidence, whether good or bad, along with the other factors and circumstances in the case in determining his guilt or innocence. The statements presented to you as having been made by the defendant are submitted for your consideration along with all the other evidence. The weight, value, credibility, and reliability of those statements are questions for your determination. If you believe from the evidence that the defendant previously made a statement inconsistent with his testimony at this trial, that previous statement may be considered by you as proof that what the defendant previously said is true. Juliana Perez Magales has testified that she was an accomplice in the commission of the crime charged in the indictment. While you may find your verdict upon her uncorroborated testimony, you should consider such testimony with great care, and you are cautioned as to the danger of convicting the defendant upon the uncorroborated testimony of an accomplice. Nevertheless, if you are satisfied from the evidence of the guilt of the defendant beyond a reasonable doubt, the defendant may be convicted upon the uncorroborated evidence of an accomplice. If you believe that the defendant was without fault in provoking or bringing on the killing of Joseph Ryan, and if you further believe that the defendant reasonably feared under the circumstances that they appeared to him, that he or others were in danger of being killed, or that he or others were in danger of great bodily harm, then the killing was in self-defense and you should find the defendant not guilty. The defendant contends that he acted in defense of another person. Under Virginia law, this defense is governed by the same principles that apply to self-defense. Number one, burden of proof. If the evidence raises a reasonable doubt as to whether the defendant acted in lawful defense of another, the jury must find him not guilty. Number two, reasonable belief of imminent danger. The defendant must have had a reasonable belief that the person he sought to protect was in imminent danger of bodily harm. All right, closing arguments.
Thank you, Your Honor. And if we can have the display for the jury activated from our table, and it does include sealed exhibits, so we'd ask it not be displayed to the gallery.
Just to the jury and not
Yes,
to the
please.
gallery.
Thank you. Yeah. Okay. Good morning. Thank you so much, not just for what you're going to do today, but for all of the time that you have spent carefully considering the evidence that we've been able to put before you, for the attention that you've paid, for the notes that you've taken, for the time that you've given up away from your daily lives, your jobs, and your families. Without your work here, Christine Banfield and Joseph Ryan would not be able to find justice. So thank you. The judge has read the instructions to you. They'll go back to the jury room with you, and you're going to have those as your guide in making your decision. I would draw your attention to the fact that you've been given 2 counts of aggravated murder, 1 count of use of a firearm in commission of murder, and 1 count of child endangerment. Talking first about the aggravated murder instructions. They have 3 parts. You'll first need to find that Brendan Banfield killed Christine Banfield and Joseph Ryan. You'll need to find that those killings were willful, deliberate, and premeditated. You'll need to find for one of the counts that those 2 murders occurred within a 3-year period, and for the other count, that those 2 murders occurred within the same transaction or occurrence. We know that they were killed during the same event within the Banfield residence, so that should knock that one out for you. 3 years, pretty simple as well. We know that they occurred on the same day. It's the first element that we're going to talk about, that Brendan Banfield killed both Christine Banfield and Joseph Ryan. We know that on February 24th, 2023, he executed his plan to murder his wife and an innocent stranger. He was in love with Juliana. He can pretend that this was a fling, an affair, he'd had them before, no big deal. He was in love with Juliana. He was afraid of losing her. He needed to get rid of his wife so that they could be together, so that they could marry, so that they could have those babies that he was picking out names for. Juliana told us how the plan was crafted and how it played out that morning in the Banfield house. But you've heard directly from our detectives and our experts the uncontradicted evidence of Brendan Banfield's culpability. You needn't rely only on Juliana's story. There has been a plethora of evidence to help you meet your burden in this case. Let's walk through just the highlights. Our digital evidence. While the digital evidence cannot tell us definitively who was behind the screen, we heard that a bunch. We know that to be true. What it can tell us is that Brendan Banfield and Juliana Perez Magales are more likely to be the ones to have set up Joe Ryan to come into the house to fake rape Christine on February 24th. There is no digital history, none, of Christine Banfield using dating sites, fetish sites, searching for pornography, talking to other men prior to the January inception of this scheme. Brendan told you that more than 10 years ago, there were incidents of affairs involving rough sex, but you have zero evidence to corroborate that self-serving statement. Think about the 2 days of Mr. Litsky's testimony for the defense and the 3 times that Detective Miller was called to this stand. If there was one scintilla of evidence that supported these claims of infidelity, of interest in sexual violence, don't you think you might have heard about it? The FetLife and Telegram contacts all occur on Christine's laptop, frequently while her phone is in use with something completely innocuous. You remember the frozen tickets, the Lululemon shopping, the family vacations the day before the murder? 2 devices, 2 different people. The FetLife and Telegram usage only ever occurred when Brendan Banfield and Juliana Perez-Magales are in the home. Is it at all plausible that this woman wouldn't take advantage of an empty house to engage in her plans for adultery? That on the 2 weekends that her husband and the nanny are out of the house, those are the 2 weekends where we see 0 FetLife activity, 0 Telegram activity? Let's look at the chats themselves. Slide 1. How many potential targets were turned down by Juliana and Brendan because they wanted to meet in person first, because they wanted to talk on the phone, because they wanted pictures that included Christine's face? Does this make any sense for someone seeking a new relationship in an area of sexual exploration that would be new to them? Why would the real Christine Banfield have been concerned about taking these safety precautions? For that matter, why would the real Christine Banfield have been searching for someone who was willing to engage in knife play when she had a blood clotting disorder? Why would Christine use a phone from a gym bathroom, a photo from a phone taken in a gym bathroom when she has all of these far better pictures available? That one keeps stumping us. There are so many more whys, and I'm sure you have plenty of them in your own heads, but the answer is the same to all of these whys, because it wasn't Christine. It was Brendan Banfield with the help of Juliana. Let's talk about our physical evidence. You heard from Detective Leach, Dr. Kessler, Ms. McCarthy, Dr. Greenspoon, Ms. Colombo. She was up there forever with all those lab sheets. They gave us a million things to think about. Slide 4. Christine Banfield died as a result of 7 stab wounds to her neck. She suffered massive blood loss. Next, the knife Brendan used to kill her was a kitchen knife with an approximately 4-inch blade, the kind you use for chopping up vegetables. This was the knife that Joe Ryan brought because Anastasia asked him to. This was not the killing knife that Brendan Banfield had envisioned for his scheme. Next, Joe Ryan was shot twice. Once in the head by Brendan Banfield, incapacitating him. A second time by Juliana in the chest, tearing a large hole through his heart and lodging in his spine. His wounds were rapidly fatal, according to Dr. Kessler, and we saw that there was little to no blood from the chest wound. Iris Daly-Graf told you that he would have been incapable of movement following that second shot. Next. We saw evidentiary confirmation of the affair. The semen stains on Juliana's bed sheets. We also saw the photos of Juliana's clothing moved into the primary bedroom when the search warrant was executed in October following the murders. We saw the photos of Brendan and Juliana together, both before and after the murders. Her photos from her Instagram, their family photos in the bedroom after the murder. We saw the records from the shooting range for the purchase of the gun and the training of Juliana to shoot it. Slide 8. We saw the deactivation of the automatic locking feature on the front door at 5:47 a.m. the morning of the murders, done from Christine's phone by the person who knew how the locking system operated, Brendan Banfield. We saw Christine's phone turned off at 6:46 a.m. and hidden in a drawer in a bar table in the kitchen. This is just not where you keep your phone. This is not where we heard that this woman kept her phone. This is not where a person who's about to engage in potentially risky behavior puts her source of help. A floor away, turned off, in a drawer, off to the side of the kitchen. Just doesn't make sense. We saw Brendan Banfield drive to McDonald's and hang out, waiting for the call from Juliana. We see their call records, 10 and 11, between Juliana, Christine's phone, which is turned off, Brendan, Christine's phone, which is turned off. They're creating a record. It's a plan. It is premeditated. We see this false attempt to check in on Christine so that they can tell the story to the police when they arrive that they did everything they possibly could. Next, we see the lock at the top of the basement door that Brendan Banfield did not think to engage to protect his daughter. Even under his own version of this event, he agrees he didn't think about it. He left his 4-year-old child in the basement with guns out, stranger in the house, and something happening that caused him to be concerned. We heard the 911 calls. We have a hang up at 7:47 with Joe moaning in the background, and then a 15-minute gap before anyone calls 911 back. 8:02, 15 minutes between when someone in that house thought the police should be there and when they finally asked for help. We saw the body-worn camera and the photos from the scene. Blankets piled near the bodies, Brendan Banfield kneeling on this blue towel, the towel that has very little staining, completely inconsistent with having been used to stop the flow of blood coming from Christine's neck. We heard that the carpet was soaked through to the subfloor. We saw Brendan Banfield's handcuffs that he didn't use, magazines full of bullets he didn't shoot, collected from him after the murders. And finally, the blood evidence. You heard from Lieutenant Giacchio and former Deputy Chief Bruce that it was Iris Dallygraff's report that finally pushed this case over the edge and brought the charges against Mr. Banfield months before Juliana decided to flip. That's how strong this evidence is. That's how reliable this evidence is. Ms. Dallygraff walked us through so many inconsistencies in this scene, proving that it had been manipulated. And you heard absolutely nothing from the defense about this evidence. Mr. Banfield gave you zero explanation for any of this evidence. Slide 15. They have provided no explanation for Christine's blood smeared on the right hand of Joe Ryan, leaving voids between the fingers. They have no explanation for the blood smeared across the top of the right onto the left, leaving that void on Joe Ryan's hand where they had been overlapping. Next. For that matter, you have no explanation from defense for how his hands came to be in that position, neatly folded on his chest, covering the bullet wound that penetrated his spine, immobilizing him. How could that have happened if you are to believe Mr. Banfield? There's been no explanation for the bloody hand-like smears on Joseph Ryan's jeans containing Christine Banfield's DNA. There's been no explanation from defense for how his jeans ended up bunched under his rear. Next slide. There's been nothing to tell us why a mixture of Joseph Ryan and Christine Banfield's blood, a mixture, could possibly have been on the inside of his waistband at the buttonhole, on the button, and on the zipper. Nothing from the defense to explain how Joe Ryan could possibly have manipulated his pants after being shot in the head, given that no other bleeding wounds were present. If his blood is on those pants, on that button, on that zipper, he was bleeding when they were touched. How could he, Joseph Ryan, have been the one to touch his button, his zipper, the waistband of his pants, to pull them down in that fashion? Brendan told you he never touched Joseph Ryan. And yet we have distinctive finger-shaped parallel lines on Joseph Ryan's arm and small circular stains consistent with blood having been dropped from above while Joseph Ryan lay on his back. Next. And then there's the blood on Joe's hip. Blood that traveled onto his body and then ran down to the floor with the assistance of gravity while he lay prone. It couldn't have come from his chest. That wound barely bled. He was laying down when blood was shed. Makes it pretty impossible that he stabbed Christine Banfield. Next. On the other hand, Brendan Banfield has cast off on his jeans. He has blood all over his hands. The blood stains on the backpack don't line up with the position of its contents. The blood on Joe's face is not consistent with his final position. And I'm sorry, I'm back to Joe's hands. This scene was manipulated. And it wasn't by Joe. It wasn't by Christine. And according to him, Juliana didn't do it. You have zero explanation from the defense as to how all of this blood evidence can be as it is. The Commonwealth gave you an explanation. Brendan Banfield and Juliana Perez Magalis colluded to kill Joseph Ryan and Christine Banfield. That makes sense. All of this evidence can leave you with no doubt that Brendan Banfield killed Joseph Ryan and Christine Banfield. That is the first element of the aggravated homicide statute. The hard work is done. Element 2, that the killing was willful, done with a bad purpose, intentional, and deliberate. There can be no question in your minds as to the intentionality of this act, the deliberateness of this act. You must also find that it was premeditated, that at some point before the killing, he decided to kill Christine and Joe. I believe that we've presented you with that evidence as well. For one of the offenses, you find that he killed 2 people within 3 years. As we've identified, same day, definitely within 3 years. For the other offense, you find that it was 2 people killed during the same transaction or occurrence. They were both killed in the room as part of the same plot, by the same person, same transaction or occurrence. The second offense is for the use of a firearm in the commission of the murders. We know from our experts that Joe Ryan died of his multiple gunshot wounds, one of which came from Brendan. If you have any question about whether or not Brendan can be held responsible when Juliana also shot Joseph Ryan, you'll have instruction O, that is concert of action. So I'm going to read to you what it says. If there is concert of action with the resulting crime, one of its incidental probable consequences, then whether such crime was originally contemplated or not, all who participate in any way in bringing it about are equally answerable and bound by the acts of every other person connected with the consummation of such resulting crime. Virginia makes it easy. Translate. If you think that Juliana Perez Magales and Brendan Banfield were working together to kill Christine and Joseph Ryan, then Brendan can be responsible for Joseph Ryan's death, regardless of which bullet did the most damage. It's not a test of either or. They were working together. That makes him equally responsible. The last charge is the endangerment to Valerie. So while in his custody, that the defendant willfully or negligently caused or permitted the life of such child to be endangered. He made it out to be Juliana's idea, but he brought Valerie into that home. He left her in the basement, knowing that Joe Ryan was upstairs. He left her in the basement while he shot and killed Joe Ryan. He left her in the basement while he stabbed his wife. He could have locked the door. He could have done this on a day she wasn't home. He could have made arrangements for someone else to have her overnight. But that didn't work with his plan. So he's guilty of this offense as well. I appreciate, again, all of the attention that you've given. I appreciate, again, all of the hard work you're about to face. Please be thoughtful in your deliberations. But at the end of the day, I don't think that there can be any reasonable doubt that Mr. Banfield has committed each and every one of the offenses that we have put before you today. Thank you.
All right, thank you. Cross-examination, Mr. Chair. I'm
Thank
sorry,
you.
closing arguments?
Sharon, may I bring a bottle of water up in front of the?
You can.
Thank
You
you.
just need to get the microphone.
It's on. Yeah, it's on something.
Good morning, ladies and gentlemen. Can you hear me? That's been a little bit of a problem, but I have it right on me at this point. I join in the Commonwealth's thanks for your attention, for the time that you've put into this. I intend to present to you with highlights of many of the things that we went through, but I can assure you I'm not going to be going through the evidence that's already been moved in. And it took a long time, and you were very patient, and everyone was very patient.
I'm sorry.
Is that better?
Just a little further up.
Can everyone hear that? Okay. I'll try to speak a little louder. Ladies and gentlemen, I join in thanking you for your time, for your attention. You could see over the nearly 3 weeks that everybody was attentive, and that's something that is something that's crucial to this process. And so I thank you. When my children were younger, I used to walk out of the house and tell them, I'm going to defend the Constitution. They didn't have any idea what that was, and oftentimes that became, okay, whatever, Dad. I was a prosecutor then. I was a prosecutor in Fairfax County. And what that meant to me was you presented a case, no matter who it was, you presented a case where you looked at all possibilities and you looked at all evidence to determine and to make sure that you were pursuing someone that the evidence would support. In this case, this was quite unusual. When we first met for the initial opening, I talked to you about some things that I thought you should look into. I thought that you should have an ear towards what is it that they're going to present as evidence. And even I was surprised that the evidence that ultimately was presented by the Commonwealth was actually from my case. The only people that were called to testify from the Commonwealth's case in chief were for body cam video, police officers, a couple of those, and Detective Terry Leach. And he was the one who identified all of the scene photos. He identified many of the pieces of evidence that were brought in. And he was able to talk a little bit about things such as the blood stains on the gun, the blood stains next to the bed. And what he told you, ladies and gentlemen, and this was the extent of, I think, their testimony in their case, was that there are numerous things within this scene that we can see in pictures, but they were never tested. There are numerous things that became the centerpiece of the fantastic story that the Commonwealth tells, yet they were never tested. For example, if I were to have the opportunity to cross-examine, say, the chief detective of this case, I might ask, why wasn't there fingerprints done, or even DNA, of this gun safe that we hear about? We hear Juliana goes into the back bathroom and talks about getting a gun. It changes a little bit over time, but if someone had said they went to the gun safe, because we're talking about guns, we're talking about shooting, why wouldn't there be some sort of evidence to either corroborate or preclude that possibility? I asked Detective Leach, he says, well, it's really up to the forensic examiners. They make the decision. In looking at the scene, you'll notice in the body cam video that you're going to be reviewing, there's a point when first responders come in and you see Brendan kneeling down next to his wife, rendering aid. He just shot Joe Ryan. He testified yesterday, he puts the gun down to his right, which is where his holster is. And he also indicates to you in his testimony yesterday that he moves the knife away from Joe Ryan. The staining on the bed where my client put the gun for the first responders, because whenever there's any sort of a shooting, you have to make sure that you are nowhere near the gun in the event that you're perceived as someone who's hostile. He puts it to the corner of the bed, and the questions that remain were, did anybody ever test the blood on that gun? And you hear from Detective Leach, you can't do that. It was already test fired, and now would be potential for contaminant. Now, we didn't test the stains down on the floor where the gun was lying in before it went up on the bed. And we didn't test the gun, which appeared to be something that a serologist could just take a swab of. Yet there's some significance placed on the fact that there was a blood stain where the gun was when it had been sitting in a puddle. And so that actually was tested. In terms of the blood stain pattern analysis, which appears to be the Commonwealth's main focus of the case now, there are questions about many of the things that Ms. Sand says were never tested. And so the conclusions that are being reached in terms of Brendan Banfield did this, he did this, he did this, based upon whatever blood analysis, is oftentimes not considering the fact that it was never tested. We don't even know whose blood it was. Those kind of things are important. And so let's go back to defending the Constitution. When you are charged with presenting a case, and I chuckle a little bit when Ms. Sand says, We haven't proved anything. We haven't shown any evidence. All we've done is show evidence. All we've done is try to get the truth out there. My client doesn't have to testify, yet he gets up there and he tells a story. He's a philanderer. We can conclude that. It's horrible. It's a horrible situation to be in. He had affairs. He accepted that. He told you, ladies and gentlemen, exactly what was going on and exactly how it went. On cross-examination, he admitted to communications that were provided, which were letters between he and Juliana when she was in jail. This is about the truth. In the beginning, you heard our duty is about fairness, our duty is about being just, all those sorts of things. Yet you don't put on any of your detectives. She's referring to the expert that they have that I called. I called 3 times, and you saw his demeanor. He was very uncomfortable. Why would he be uncomfortable? Why would he have been uncomfortable talking about his work? And we dug for it, and he ultimately said, the executive summary and the data remain the same. The only thing that changed is Juliana Perez Magalay's statement. Excuse me 1 second. So there, number one, that's the first time that anyone in this case, which was when I called him, conclusively said the entire catfishing theory changed upon her plea deal. So let's talk a little bit about confirmation bias, or I think we referred to it when we were talking in closing, or when I was talking in closing about a rush to judgment. You've heard from detectives from Fairfax County. Detective Smith came up and she told you the catfish theory started within weeks of the event. She says, that's not how we do it. We look to the evidence and we follow the evidence. Seems like a pretty reasonable way to go. And that was something that I asked of pretty much everyone that was in some sort of investigatory capacity. That is the way cases go, is the evidence leads you where you're going to go. But lo and behold, what we find out is that that theory is being peddled by the 2 people in command staff, actually the 3 people in command staff that you also heard from. You heard from from Mr. Bruch, formerly Deputy Chief Bruch, that when Brendan Miller presented his findings, well, first of all, he said, I didn't agree with his report. And I said, well, what, if any, analysis of the raw data did you do in order to make that statement, I don't agree with this report? He said, well, it wasn't that. I don't know about the data, though he said he was a computer forensic PhD. He didn't take the time to do that. So I said, okay, well, did you ever have Detective Miller come in and walk you through it? Like, show your work? Well, we talked about it quite often, but did you, in fact, have him go through everything that he did to arrive at his work? No, we didn't do that. He speaks to Lieutenant Giaccio at the time, who appears to have a direct line to him, obviating anybody else within the command staff. And what you'll see, and you'll see it in the evidence, there are emails where soon after Juliana Perez Magalhaes changes her story, there are emails to Sergeant Ames. And you remember Sergeant Ames, he came to the stand based upon my subpoena and my calling him. And Sergeant Ames was not comfortable. And you could see any of these police witnesses are just not comfortable coming to the stand on my subpoenas and answering my questions. But he did answer them. And what you saw were emails. Those emails were essentially they were just kind of forwarding it up the chain so that his supervisors knew. And he was very candid about it. I was new. I wasn't sure how to deal with a situation like this. I'd never dealt with a situation like this. But what the situation was Detective Miller's executive summary being sent up the chain to Sergeant Ames, who was in a different division than Lieutenant Giacchio, saying there's different ways, there's 3 different emails that you'll see. Brendan Miller has got to look over this, and he's got to go line by line and explain how he got it wrong, things such as that. The final one is to Sergeant Ames. I can tell you that every single conclusion in his report was wrong. He's going to have to do something in order to, and it's kind of essentially, he's going to have to change this report because it needs to conform with the proffer of Juliana Perez Magalhaes. So that's twice now. 2 different people that I called to the stand that essentially confirms that everything changes when she comes in and testifies. Let's get back to confirmation bias, rush to judgment. When you have people in a supervisory nature, you have a command staff chain of command, and the highest people are pushing you on your work product. That's why you look like the people that are up here testifying, because they're sitting on the fence. They're sitting on a razor, and neither side is good for them. But they came before us and they testified. And they testified as to the truth. Detective Miller spoke the truth, and you could see it. Detective Miller, his work was concurred by Mr. Litsky, who you heard for quite often during this period of time. And it was peer reviewed and it was concurred by someone, a third party. You heard Detective Miller say, that's never been done in Fairfax County. You heard him say, I didn't ask for that peer review. He didn't know who asked for that peer review. Why would you want a peer review of something if it wasn't for it to change? So once again, not happy with that, not happy with the work product. There's nothing to indicate in Detective Miller's background anything but stellar expertise. But he wasn't introduced as an expert for the Commonwealth. Now, this is where this whole theory went wrong. They discredited him. They disregarded him. And they didn't listen to him. And that's a problem. That's a problem for their case. Because there are things in digital forensics that had he been involved with the group that was talking to Juliana Perez Magalhaes, he would have been able to guide them in terms of this is where the digital forensics is in conflict with you. And you heard me testify, or I'm sorry, you heard me ask questions of many of these detectives who might have been involved, did anybody ever challenge her? Were you present when she recanted for the first time? Well, we couldn't ask that of anyone because the detectives that were in the room have not been called. The detectives that were in the room, I didn't call. And so we don't know anything, but we heard Detective Miller, and he had viewed it, and he said, when I asked him, were there challenges to what was said? He said, no, it was pretty free-flowing. To me, that tells you that whatever the story you're telling us is great, because we're getting Brendan Banfield based upon that. Once again, confirmation bias. The first few weeks after the death of Christine Banfield becomes this theory of catfishing, which is what Juliana Perez Magalhães provides to this. Now let's talk a little bit about digital forensics. And I'm not going to try to use the computer to show these to you because that was excruciating at times. But I think we've gone through it with significant enough detail that when you go back to look at the exhibits, and I'll tell you which exhibits if you wish to write them down, you're going to be able to see exactly what Mr. Litsky was saying. It's complicated. It's been complicated for me since the beginning, but it's not necessarily an easy grasp. But I would ask that you take the opportunity. You're going to have all this evidence to review this particular area. So some of you may have been asking about January, or may wonder about January 9th. That's a significant date in this investigation, because that's the day when the Gmail account, called the suspect Gmail account, was started. Let's just look at how Juliana Perez Magalhães managed this. Regarding the Gmail setup on January 9, 2023, Juliana told the Commonwealth that she was at the house with Brendan when she witnessed him create the Gmail account that was used to kick off the entire catfishing scheme. The Commonwealth took her at her word. The police didn't make any effort to corroborate her story. The one detective who stood up and said the evidence contradicted her story was transferred off the case. I think the words were from then Deputy Chief Bruce, "That guy will never work on another digital forensics case in major crimes as long as I'm here." He admitted it. There was no dancing around. He admitted it. So you have something that's in opposition to whatever the theory is that you're trying to peddle, and you're in the command staff, you're high up in the police department, you can just transfer them. And so it was from that point on, Detective Miller was of no benefit to the police because no one would utilize him once the stamp of disapproval had hit him. He was moved over to child sex. Juliana told the same story to you here in court, and it's a lie. The account wasn't created with Christine's phone. I'm sorry, the account was created with Christine's phone, not her laptop, which was the story that Juliana had told. Juliana wasn't even home. She hadn't witnessed anything. And you saw the presentation, and that would be, the evidence would be Exhibit 297, Exhibit 294, and Exhibit 295. They're all in relation. You'd be looking at the Google records, the T-Mobile records, and the subsequent map of where the location was. You heard from Mr. Litsky that the Gmail account is crucial. They all interact. The Gmail account is necessary to get the messages relating to the FetLife, and then the Telegram was created as part of this, whatever we want to call it at this point. Because every other event going forward requires Brendan, based upon her statement that she didn't have anything to do it, she didn't know how to do the Gmail account, she didn't know anything about the setup, requires Brendan to be involved, or Christine. So let's look at this. There was a period of time, and you heard evidence of it, Brendan wasn't at home. January 23rd, there was a Gmail login at 11:22. That's Defense Exhibit 245. FetLife was accessed. In the communications, you heard Mr. Litsky opine as an expert that catfishing is not a scheme where one talks about their husband or talks about how's your experience on this site. The catfishing in the truest form of the government's theory is we just want to get someone on the hook, and then person's gonna come, and then we're gonna do what we did in there in the house. It's not consistent with catfishing. And you'll see, based upon the records relating to January 23rd, there was only one adult in the home at that time. And that adult was Christine Banfield. January 30th, there are two Gmail logins. 10:36 and 11:03. Exhibits Brendan Banfield 251 and Brendan Banfield 252. Brendan wasn't home. That can be shown. So there are two adults in the house. Christine Banfield and Juliana Perez Magalhaes. Juliana testified to all of you. She doesn't know anything about the Gmail. She doesn't know how to activate it. Well, somebody activated it that day. Somebody logged in twice. And there are two adults in the house. Either Juliana's lying again, and she did figure out how to do Gmail, or this was Christine Banfield. Digital forensics, oftentimes, for people who don't understand it, will say things like, well, isn't it possible this? Well, you see what happens when an investigator is looking into, trying to get attribution. They're looking at all sorts of different data facts in order to make a determination, make an opinion. It's not as easy as saying, well, isn't it possible this? There's more to it. And once again, digital forensics is not being given the strength that it is due. February 7th, 2023, Gmail login at 10:02 p.m. There's only two adults in the house. Brendan Banfield can be identified as being out of the house, and one of whom says she never did anything with Gmail. That's BB 257 It's been presented to you. You can recollect what it was that was said, but what we know is that Brendan was out of the house. What we know is that Juliana was there, and we know that Christine was there. February 13th, 2023. There are logins in the morning in the 7 a.m. hour. Well, what we know from digital forensics is that Brendan left at 6:05. And at 6:12, he was at Tyson's Corner based upon his Easy Pass records. At 6:17, he was already to Alexandria. And soon thereafter, he was in Cheltenham, which is the Federal Law Enforcement Training Center. They call it FLETC. Well, while he's on the road, while he's at the FLETC Training Center doing his training, there are 2 logins. And there are 2 possible adults there. Juliana Perez Magalhães, who has said she doesn't know how to do that, and Christine Banfield. 2:17, you'll see Gmail logins at 11:19, 11:23, Exhibit 262, 263, same thing. 2 possible adults. Brendan Banfield was out of the house. One said she never did anything with Gmail. A fact that I think is very important in the discovery that was provided both to Juliana Perez Magalhães as well as my client in preparation for her trial. FetLife was in the discovery, but Gmail was never in focus. Never in focus. So her testimony, there's a comfort level with FetLife because she saw it in discovery. She didn't see the Gmail. And isn't that a coincidence that when asked any details, she says, I don't know. When she says, I don't know, for 5 or 6 questions, I hope you recall it, I recall it vividly. She said, if you keep asking these questions, I'm just going to say, I don't know. And she continued to do that. Were my questions challenging, like the kind of questions that a detective might do? No, we were just looking for details. We were looking for details because we wanted to try to iron out what are these situations here. She was unwilling. She didn't know, but she knew I was digging for something. But if you look at the way she testified to all of you in direct, she was led to a certain statement or a certain fact, and she stated it. In cross-examination, I asked anything about that. Do you know who was in the house? Do you know where you were? Were you on the phone on WhatsApp with Christine prior to that? Where were you located at the time that this call took place? I don't know. I don't know. If that's what it says, I don't know. You know, there were a series of similar answers. Once again, her role has grown in importance for this case. It's along with Deputy Chief Bruce and Lieutenant Giacchio, she's pushing it on through her deal. Now, one of the things that I talked to you all about, and one of the lengthy cross-examinations was relating to a group of exhibits which were number 1 through number 69. And you'll see it. It was highlighted. I think you've seen it for a brief period of time, but we were moving along. Look at that. You'll see these are the personal letters that she would write to my client. And those personal letters, I believe, is the closest to the truth that you will have heard from Juliana Perez Magalhães. She was in a situation which really was affecting her. And it would affect anyone. And she was telling you how she was feeling. She was telling you what she thought. There were things that were relevant to this case. They're trying to make me turn on you. I'm not going to do it. I don't have anything to say. There's nothing that I can do to help them with. And then you'd see letters as the time went on. I don't know if I can live like this anymore. I think it's better for me to end. And then as she gets closer to a preliminary hearing in April of 2024, you start to see real angst and real worry. And they're coming to her and asking her if she'll testify against my client, because that's what they wanted from the beginning. She was a pawn in trying to get to my client. You'll see this timeline in these letters. It goes toward July. July was the date of her first trial. And you'll see, and I'm not suggesting what she's saying about her lawyer is correct, but it was obviously something that was on her mind, and she didn't feel like she had the support. At that point, if you think about it, the only support that she was having was from Brendan. Brendan was not arrested. Brendan was there communicating with her. Brendan's mom was actually supporting her lifestyle in the jail in terms of commissary, things like that, and also supporting her by having paid for a lawyer. Around August, you'll see in these letters, it gets to be real despair. And then you can almost see hope just drop right away from her when she hears that Brendan's arrested. And then she testified. She went into the hospital from October 13th to October 23rd. And as soon as she's released and back to the jail, the deal is done. She's told, if you testify against him, we'll recommend time served disposition. She can go back to Brazil, be with her mom, create her new life. And we know a little bit about the new life that she's planning on creating. And you have it in the documents that are before you. She's been negotiating with people who are connected to Netflix. She's been negotiating with people who are connected to Hulu. She's been talking to every other news media at first to try to see if they just put $50 into her commissary. But then she realized, hey, there may be something here. She's invented, she's gonna try to write letters. She's gonna try to write a book. She wants to have a documentary. She wants to have a series. And she's about to sign or about to agree when her lawyer steps in and says, don't sign that. And so around March of 2025, you see negotiations essentially end. The number was in the area of $25,000, and it was going to be sent to her mother in Brazil. It's a lot of money in Brazil. And so where's the downside for her? Where's the downside for her? I mean, there are plenty of people who would make that decision, given the circumstances, given you're 2 weeks from the trial, when your attorney asked for a continuance. And oddly enough, he was asking to find a digital forensic examiner. If they'd done that, maybe that wouldn't have happened. Maybe they would have realized how strong the digital forensics examinations are. Her entire story has been bought and paid for. First, with her freedom, and then now a little bit on the back end. There's a jury instruction in here that says something about corroborated, uncorroborated testimony, and you should be careful of it. Now, how did they try to corroborate her? So isn't this funny? They're trying to bolster the witness who's the centerpiece of their entire case. Well, they found something when my client was arrested on his laptop that said they'd just gotten vinyl light windows in December. So sitting in the meeting with whomever, they say, can you tell us anything about these vinyl light windows? They're triple paned, probably really good. I wasn't there, I don't know. But the story she gave was that, I mean, fantastic. We got the triple pane windows because Brendan wanted to make sure you couldn't hear a gunshot in the bedroom. And and she says, he asked me to go outside and scream to see if the windows, and she says, I'm not going to do that. So she ended up staying inside and saying Brendan went out and screamed. Well, you heard the test. I mean, this gentleman from Vinyl Light Windows came in. They trotted him up there, and he said, "Yeah, you know, we met in January. That was when we first talked about this, and it wasn't just the windows for the bedroom, which is what Juliana said. It was the full windows, and then you saw an artifact on Facebook that is Christine Banfield actually talking to her neighbors about the numerous vendors that they had been working with to try to get a quote from December 2021. So this is well before Juliana came on the scene, but it's an opportunity to try to make her appear in the know, to corroborate her. Well, that was a disaster, and that didn't work. And you heard the gentleman, you know, what the life cycle of order to quotes to all those things, they were all done well before any sort of relationship started with Brendan. Confirmation bias. Rush to judgment. It continues on. Detective Leah Smith tells us the catfish theory was told to them within 2 weeks. She goes on to talk about the theory and investigation and the direction it was going in. During a period of time soon thereafter, Detective Miller tells of his transfer against his will because he was advised he'd never work on major crimes cases again. Sergeant Ames, after receiving communications from Lieutenant Giacchio, immediately sends it up the chain. Could be just the way he does things, or it could be read those emails. Hey, I'm being asked to do this. I need some support here. When you have a theory that gets pushed from non-investigative command staff, and you have a theory that the investigators look at, then you create something called tunnel vision. And that tunnel vision, if you're following what essentially are orders, is to the exclusion of any other evidence, any other theory, such as maybe this is a rekindling of previous fantasies, and the guy who brought the knife to the house is the stabber. You can see how that theory is going to be pushed aside. And you can see how that's not very noteworthy for purposes of media or other attention. Once again, rush to judgment. Catfishing. If you're catfishing, meaning you're trying to get the one guy, Joe Ryan, to come to the house so that you can do this gruesome act, why are you saying anything about, I can't have marks on my face or my body? If you're catfishing, why would that matter? It doesn't make sense. It's inconsistent. However, if you're interested in dabbling in this lifestyle or getting back into it, however you want to say, then that makes perfect sense. There's 9 different conversations on FetLife with different people. And you have all of the FetLife communications. And you can see, why would you have discussions where you're bringing things like no marks, anything like that? All you need is one if you're going to carry out what the government's theory is. Why would you give anyone details about your work or your home or your husband if you were catfishing? I mean, if it's truly catfishing, you're looking for the biggest pile of people that might be considered. If you're telling someone that you have a husband and you want them to come over to the house, why would anybody come? You're losing the potential people that you might want to have there who are violent or, love to do all the things that Juliana has said. Why would you do that if you're catfishing? It doesn't make sense. On February 13th, 2023, why would there be generic research on secure apps for communications? In fact, why was there even a need to transition to Telegram? Because if you're on FetLife, it's clear there are FetLife communications. And so in the world of catfishing, if you think about it, you want to do as few things that can get you caught. So what was the leap to Telegram? It doesn't make any sense. In fact, this whole theory doesn't make any sense. And the only way the government can make any sense of it is if Juliana Perez Magalhaes adopts their story once again. As late as February 19th, which would be 5 days before Christine Banfield's death, Under the government's theory, there were dates that were being explored with 5 different FetLife users. Why? If Joe's already coming, why? It doesn't make sense. It doesn't make sense. Juliana Perez Magalhaes is doing what probably anyone would do who's from another country, who comes here for an adventure, which is what au pair exchange is. It's essentially a cultural exchange. And the idea is you get to live in the country and you get to live like people in the United States. And then you go back at the end of your time. She knew at the point when she was hospitalized to the point of sickness as a result of what was going on in her life that she had to do something. And the Commonwealth and the police broke her. She turned down a misdemeanor, according to her, in January, on January 1st, and you'll see it in the communications. She turned down a misdemeanor, and all she had to do was testify against Brendan. In July, you hear her recounting her meeting with her lawyer, where her lawyer floats the idea, what about a manslaughter, time served, and you don't have to testify against Brendan. She agreed to that. That was never what they were talking about. That was never what they wanted to do. You heard from Sergeant Matt Nilsson, who briefly came in, and he was one of the homicide people during the time of the killing of Christine Banfield. He's since rotated out to another division. But he came in and he said the whole goal of arresting Juliana was to flip her against Brendan. Once again, further corroboration. We knew it. We saw it from her letters. And now you have someone who was involved saying, yeah, that was what we wanted to do. That's why we did it. They broke her. In talking about the blood work and the blood testimony, it was suggested by the Commonwealth that we hadn't proven anything. The Commonwealth had not shown anything. Well, I beg to differ. You heard from Leanne Singley. Leanne Singley is an expert. She's an expert with tremendous credentials, and she's an expert in truth in terms of what she's allowed to say, what she can say, what she can't say. And she speaks to you in the language of bloodstain pattern analysis. She's not talking about possibilities. She's talking about facts. She's a scientist. Her counterpart from the Commonwealth was willing to entertain any possibilities. In fact, questioning of her was, well, isn't it possible this? Isn't it possible this? Isn't it possible this? And oftentimes you would hear her respond, well, that wouldn't be something that I would have expected to see, which is a very interesting statement if you think about it. What is it that she's expecting to see? Which makes you wonder, who's telling her what she should be seeing? And does it fit the narrative? So let's go to Leanne Singley. She tells you of the account of the events. Ryan stabbed Christine in the neck. Brendan shot Ryan in self-defense. Brendan rendering aid to Christine. Ryan moved toward Brendan and grabbed Brendan's arm. You see that in the videos. And Juliana shot Ryan to end the threat. What Leanne Singley tells you is all of the blood evidence supports this. Ryan brought the knife. That'll be Commonwealth's Exhibit 10. The knife has blood on it with Christine's DNA on the blade and Ryan's DNA on the handle. Ryan has Christine's blood on his hand as well as a puncture wound, which the medical examiner says is consistent with the knife. And if you look at the knife, it's described in the certificates of analysis as testing underneath the handle by the edge of the blade. And if you look at the marks on Joseph Ryan's hand, the medical examiner states that these wounds are consistent with that knife. Which reminds me, the medical examiner also said that Joe Ryan was capable of movement. And you can recall your own notes on that. That was very clear, which is in absolute conflict with Ms. Groff and is in absolute conflict with the Commonwealth's theory. She further goes on to say, Ryan has Christine's, the blood on his hand shows his hand was closed when the blood was deposited. That's that closed fingers we were talking about. That's what the Commonwealth was talking about in terms of having nothing going in between the fingers. That's holding a knife. That's how that happens, because you're holding it very rigid in order to do that. The bloody handprint on Ryan's thigh is consistent with him touching his own leg with his bloody hands. That's Ms. Groff. The stains on Brendan's jeans and shirt are what you would expect he would get while giving aid to Christine. And we see it. We see it on the body-worn camera. We see it on the still shots. He's leaning down. He's down there on his knees. Testimony by Ms. Groff and the ME indicated that Ryan could move after the gunshot. And what's most important is that there's a DNA mixture of Christine and Ryan on the arm of the jacket where Brendan said he was grabbed. 3 times. 3 times when he was being told by the first responders, go into the bathroom. He said, they're asking, is he okay? He hit me on the right side under the shoulder blade by the arm. He said that. Then in the ambulance, you'll hear that. He says, when they're asking, are you okay? Are you okay? I don't think I'm injured. But he did hit me on the backside of my jacket. In the ambulance, they grabbed the jacket. And then when he was in the hospital, the doctor asks, and he says, he hit me on the back, but I'm not injured. The critical part of that is that the DNA mixture of Christine's blood and Joe Ryan's blood on the jacket was, if you were listening to my client yesterday, he tells you that that was Joe Ryan after he shot him. That mixture of blood with Christine and Joe Ryan himself had to be after Joe Ryan had stabbed Christine in the neck. And that's the way her blood would get on him in order to be able to get the back of my client's jacket. That's what Ms. Singley says. And that's why the Commonwealth is so intent on saying this had to have been on the floor, this had to have been on the bed. But there's no evidence to support that. There's a story to support it, but there's no evidence to support that. The evidence in terms of what happened in that room, and the crucial evidence is spot A on the back of the jacket, and you have it in evidence, and you also have it under Commonwealth's Exhibit 160, 161, and 167. Officer, I'm sorry, the young man who was 1 year on, I forget his name now, he was brought up to introduce his video and then was asked, well, why'd you let him wash his hands? And you can see my client, for a period of probably 40 minutes, is literally walking around, you know, in a trance from what he was just involved with. And he was walking around with blood all over his hand to the bathroom and did it right there after being removed from rendering aid. Brendan's DNA does not show up anywhere on Joe Ryan, which is consistent with what he told you, which is that he never touched Joe Ryan. There's no indication that there was any sort of movement. And frankly, what's the possibility, I guess I'll use the same word, that a 185-pound man would have been moved if he was otherwise dead? It's not an easy task. And Brendan Banfield's an athletic guy, but I don't think he's up to moving 200 pounds in that sort of way. So that's an absolute red herring in this. When
Mr. Carroll, do you have quite a bit more? I just want to give him a chance to take a
probably
break.
about another half hour.
Yes, let's go ahead and take our morning recess for 15 minutes. Please do not discuss the case at this time and do not do any outside research.
Been watching the closing arguments in the Fairfax County courtroom, of course, the double murder trial of Brendan Banfield. First of all,
Do you think we should maybe go back in for a moment? It does look like the judge might be saying something.
maybe something about the time.
Okay,
here.
actually,
Yeah.
never mind. She is getting up. So, you know, we've been hearing her say a few things as they're coming out of the breaks and going into the break. So it does look like they're on their break.
So this should be about a 15-minute break. We see your comments. We see all of it on our YouTube channel. So keep those comments coming. A lot of you have interesting thoughts about what's happened so far. Let's see here. First, we had Jenna Sands, the prosecutor, do the closing argument on behalf of the state. That took about 30 minutes.
Not even really,
Not
you know?
even. And she got straight to the point, really laying out the case. And just to remind everybody what Brendan Banfield is facing: 2 counts of aggravated murder, 1 count of using a firearm to commit a felony, and 1 count of child endangerment.
Yeah.
And so,
should we go through those charges a little bit?
yeah,
and
sure.
explain?
Let's do
So at the
that.
beginning of court today, we did hear the judge explain each of these charges to the jury and what they need to keep in mind. So with the first one that Annie mentioned, the aggravated murder within 3 years, with that one, they have to decide whether or not he killed Brendan Banfield, killed both Christine Banfield and Joseph Ryan. He has to be found guilty of killing both of them or not killing either of them. And it also has that premeditated attachment. It has to be that it was willful, deliberate, and premeditated and happened within 3 years. The next charge that you mentioned, the aggravated murder, same act or transaction, same concept, that he killed both Christine and Joseph, that it was willful, deliberate, and premeditated. And then there's that firearm charge. That just is that he attempted to commit murder while in commission of a firearm. And then the child abuse charge, which is that other one that we've been talking about. It's that Brendan had custody and that he willfully or negligently put that child's life in danger.
Yes. We ended with John Carroll, the defense he is not done yet with his
No.
closing argument. They
30
broke
more minutes.
30 more minutes, he said. I will say he was about an hour in. We were listening to him for an hour. He said about 30 more minutes. And a reminder that, you know, the defense's job is not to explain what really happened. His main priority is to raise a reasonable doubt in
Poke holes in the theory that the Commonwealth has provided.
Dismantle this this story that the prosecutors are accusing Brendan of. So he's really kind of taking us. I felt like he started off with, you know, the evidence piece, saying that there were numerous things within the scene that were never tested, but we saw it. So he kind of relied on that forensic piece. Why weren't fingerprints done with the gun safe? We, you know, heard that Juliana had gone back to grab the gun from Brendan's gun safe. Did anyone test the blood on the gun? The stains weren't tested. So he's really trying to raise those questions.
Yeah, and he is trying to say that, you know, he's alluding to the fact that he believes the police involved in this case did not do that job. He also, he made mention that none of the homicide detectives came up to the stand were called by the prosecution. And that was something he brought up in his opening statements as well, that you're not going to hear from the prosecution them call any of those homicide detectives because those original homicide detectives didn't necessarily fall in line with the prosecution's theory and case here.
Right. So we'll see what he has to say after we come back from this break. Jenna opened up the closing arguments, you know, thanking the jury members for being there. Of course, we also experienced within the last week this snowstorm, so folks had to make adjustments to their family life and digging out of the snow and everything. So she did start with that sentiment and then got right into it. I mean, rapid fire.
Which is what we've seen from her.
We have seen that. That seems to be her style, just getting straight to the point and backing it up with support and facts and really emphasizing, you know, she said, you've heard from experts, detectives, Brendan's unreliability, the plethora of evidence that we've presented, and basically accusing Brendan of being the mastermind behind this elaborate plan to kill his wife, Christine, and Joseph Ryan so that he and this au pair, the nanny that lived with them, could just run off and be in love, even went as far as, you know, talking about the letters of, you know, professing his love, and they were coming up with baby names, or he did, right? So she's really trying to lay that case down.
Yeah, and where we heard John Carroll saying, Brendan Banfield laid it all out for you. He was honest about his affairs. He told you the truth. He aired out his dirty laundry. She's saying, well, he kind of lied also. He said the relationship wasn't serious, but then he's saying, I love you to her.
Along those lines, something very important is that Jenna pointed out there is no evidence of Christine having an affair or talking to other men, and no messages of this, no FetLife trail of Christine, you know, wanting to have this type of sex fantasy, previously. And she also had a blood clot disorder. She lived with this, and this was known by Brendan. He admitted, you know, he said, I knew about it. So she's raising that question of why would someone who is living with a blood clot disorder want to engage in rough sex?
And specifically the knife play activity. Which is what was brought up. And I thought also, going back to the affairs, you know, Brendan testified that he had multiple affairs, that that Christine knew about some of them. But he also said Christine had multiple affairs. And I thought it was interesting today when Jenna Sands, the prosecutor, she said that affair was 10 years ago that you're saying happened, but where's your proof? You could have called that person to the stand, or you could have called these people that you're claiming Christine had these conversations with.
There was no evidence.
Right. They didn't provide any evidence there. Another big thing that really stood out for me is that conversation. You know, we heard the jury get the instructions from Judge Penny Oscarati about what they are to consider when making their decision. And towards the end there, we heard Jenna Sands say Brendan and Juliana worked together. So just because, and specifically the portion about Joseph Ryan, because we know both Brendan and Juliana shot Joseph Ryan, she was saying, you know, Brendan fired the first shot to Joseph Ryan's head. Juliana fired the second shot. And the medical examiner, or one of the witnesses called, said that that first shot by Brendan was rapidly fatal. So she made a point to say that Brendan and Juliana were working together. And if you believe they were working together, that means you can say Brendan killed Joseph Ryan, even though it may be unclear whose shot was the fatal shot.
Right. So that was another key point. The physical evidence. So they presented the prosecutor presented a lot of physical evidence, and that was her point. We presented to you that Christine died of 7 stab wounds to her neck. She suffered massive blood loss. The knife that Brendan used to kill her had a 4-inch blade. This is the knife that Joseph Ryan brought to the home, thinking that he would be involved with the sex fantasy.
He was instructed to in those telegram messages that we saw from FetLife.
Right. And she also mentioned the semen stains on Juliana's bed sheets as far as this love affair. It is clear a love affair took place. We saw the semen stains on Juliana's bed sheets. The clothes had been moved to the primary bedroom after the murders occurred. Also, the photos of them. We saw that photo before and after, right?
Of the bedroom,
in the bedroom, when she moved into the primary bedroom.
Yeah, and to be clear about the semen stains, we're talking about Juliana's bedroom for that. There were no semen stains found from Joseph Ryan in the bedroom with Christine. So we're talking about 2 different sets of people here, right? Like Juliana and Brendan they've never denied that relationship. The question, of course, being, were Joseph and Christine having a relationship? And that doesn't seem to be a thing that either side has really said. They're just saying Christine invited Joseph Ryan, but it's not clear that is actually, there's any proof to that from what we've seen.
Yeah. Also, what stood out to me was her bringing up the 911 call, how Christine's phone had been turned off that morning. It was hidden in the kitchen. And I don't know, I mean, maybe some people do, but she raised the point, who does that? Who turns off their phone and just tosses it into the kitchen drawer?
Yeah, and an important note here, when one of the officers testified and showed the crime scene photos, we saw the photos of where they found Christine's laptop and her phone. It was downstairs in the kitchen. But when Brendan testified, he said that when he left for work the morning of February 24th, 2023, he said Christine was awake, she was in her bed, and she had both her laptop and her cell phone.
Right.
So that kind of contradicts his story about it, right?
Yeah, right. The 911 coming in, the first one I believe was at 7:47. That was a hang up, but in the background you could hear Joe Ryan moaning.
And what's interesting there is Juliana testified it was Joseph Ryan's voice moaning. That's what the prosecution has said. But then yesterday, the defense called up this witness who compared the audio of the Banfields dog, which the dog's name is Lily, and the noise Lily, which I believe she's a husky, makes when she's whining or growling, that moaning sound. And he said he compared the 2 audio clips and found they were similar. But then the prosecution got back up there and said, but you're not clear that those clips aren't humans. You're just saying they're the same. You don't know if they're humans. You can't really prove anything here. So kind of put a stop to that testimony.
Yeah. What else stood out to you, Katie?
I mean, so many things, right? I know we talked about how Jenna Sands moved so quickly. We saw that in opening. We saw both of them move rather quickly, but through the process of this trial, we've seen Jenna continue to move quick, to the point, very focused on getting things done. And then John Carroll seems to really slow down and take his time here. He introduced more than 300 pieces of evidence, and we saw him go through each piece of evidence clearly. And he even said to the jurors today, it may have been excruciating at points, but I really want you to pay attention to the evidence I've provided you. And he offered to highlight which key pieces of evidence they really need to look at. So I think that was for me. What about for you?
Yeah. Well, I think that Jenna definitely went line by line and walked us through the past 3 weeks, starting with the storyline of what she believes happened or the state state believes happened, and then really kind of going right into making it easy for the jury members to digest. We have presented you with a plethora of evidence, and she starts with the digital history of Christine using fetish sites, talking to other men. There was no digital history of that. There was no evidence of that. Makes that clear. Then goes into Brendan saying that there were affairs and there was rough sex, but again, zero evidence of that. The FetLife telegram messages, only occurred when Juliana and Brendan were in the home. The 2 weekends that Juliana and Brendan were out of the home, there was zero activity on these FetLife websites, right? Or the messenger. So really kind of honing in on specific things so that the jury members can sort of reflect back, that's right, and have a clear idea of what the state is saying.
Yeah, and it's interesting because she had so many valid points about the messaging and when things were happening, but then we did hear John Carroll get up there. I don't know if you caught it. It was in the middle. He had been going on for quite a while, but there was a moment where he said, one of the conversations on FetLife, it shows, based on their forensic evidence, which again connects devices, it doesn't tell you who's in control of the device at that moment. He's just saying it was Christine's device or it was Juliana's device. And he said one of the devices owned by one of them was being used in the Banfield home while Brendan Banfield was at training. He was at, I think Flexus is the name of the training he was at. So he was saying if Brendan was the planner, the one who came up with this elaborate plan, then how was he at FBI training down in Flexus when these conversations were happening? So, he is still poking little holes in the theory and just, again, bringing up questions for the jurors to walk away with and be like, wait, does that make sense? Does that all line up?
Does that make sense?
Mhm.
I think that is what Jenna was sort of getting at, is anyone with common sense, if you hear this story that Brendan has shared, like, I need you to really think about it. Who does this? Who does that? And I really think that she was trying to just kind of get into their minds with that. The 911 question that she asked yesterday, why did you not call 911 at any point until after you shot Joseph Ryan?
Yeah.
That was when the 911 call was made.
And he had an answer for everything, right? And he said his answer was that he thought it was just another one of the affairs. He didn't think police needed to be involved. And, I think that's what we saw from him, right? Like, I'm curious to see when Frank comes back, what he thinks of Brendan. Again, he did tell me the first day he thought Brendan on day 1 would get a C- in his opinion. Day 2, he said he did a little bit better. He was quick at answering the questions we heard from Jenna Sands. I don't know, for those of you who weren't with us this morning, we can play you some highlights of day 2 of testimony for Brendan Banfield. We did hear him testify both day 1 and day 2, but or if we're able to, can we play you some clips from day 2 of testimony for Brendan?
I heard the sounds of, I would say, moaning, as well as sound of skin on skin contact.
What did you think was going on at that point?
Sex.
Why didn't you call 911 at that point?
Well, I believe that it was an affair. I thought about just ignoring the situation and going to work. The sound, I guess, sounded like it changed to me. Instead of what I thought was the sounds of sex, I thought that the impact sounds sounded forceful, and that Christine's moaning sounded painful and not pleasurable.
Walked up the stairs with the gun out. Is that accurate?
Yes,
Okay. And when you turned and saw Juliana had followed you, at that point in time, you're worried that bad things are happening, correct?
yes, I am.
Did you tell her to call 911 at that point?
No, I was moving quickly towards the door.
Did you tell her to go back downstairs and get your daughter out of the house at that point?
I wasn't worried about Juliana at that point. I was worried about Christine.
Okay, and you weren't worried about your daughter at that point either then, right?
I don't think it was on the top of my mind when I believed that Christine is being injured, and that was at the forefront of my mind. I don't know why she chose to come to the house.
Okay, but you're law enforcement and this is your house. You're not going to tell them what to do to ensure that they are safe when you have this doubt about what's going on?
I understand that. And it may have been a mistake that I didn't send them back out. And it's something that I've thought about many times. Christine was, I would describe as nude and on all fours. And Joe Ryan was behind her. He was clothed. He was looking directly at me. I had never seen Joseph Ryan before.
Have you ever had any communications with him before?
On February 24th is the only time I had communications with him in that room. I did not want to shoot him. He did a very forceful stab towards Christine. Christine told me that she was bleeding out and that that she was sorry and that she loved me. He was stabbing her. I mean, I wish I shot him earlier.
Now that you've heard all of the evidence, every possible hearing that could happen in this case has happened. Now you are ready to tell us what happened. Is that accurate?
I was ready to tell what happened at Juliana's testimony, at Juliana's trial when that was scheduled for November.
These very strong feelings, these let's be together for the rest of our lives feelings did not exist when your wife was alive.
Correct. Juliana and I weren't even together when.
All right. Yeah, it looks like court may be starting shortly. It does look like the judge is getting some paperwork together. I'm not quite sure. Has it been 15 minutes? It feels like that went very quickly, right, Annie?
It did go by quickly, but once the cameras are on the judge, that's when we're going to take you live into the courtroom. We'll take you back live into the Brendan Banfield murder trial out of Fairfax County.
All right, thank you. All right, Mr. Carroll, you can continue. Thank you.
Thank you, Your Honor. Ladies and gentlemen, we left off in the discussion of the bloodstain pattern analysis. And what was an interesting moment in terms of the experts was when there was talk of bloodstain inside the zipper and around that area. But if you look at the DLI report, which is number 169, you'll see in that report, they were looking actually for touch DNA. They weren't actually looking for blood staining. They identified blood staining, but the whole point of it was to find Brendan Banfield's touch DNA on the inside of Joe's pants based upon some theory that he was either pulling the pants off or moving them or something like that. And that was one of the reasons why they went to a private lab to try to do that. And it didn't pan out. And you'll see the report. Now, in terms of the evidence on the bloodstain pattern analysis, let me just do a rundown. With regard to the knife, it was identified as being bloodstained. Leanne Singley said that. She negated the possibility of anything being wiped off, which might be one of the things that you might find in a situation of the nature of the government's theory, but she's negated that. That it contained DNA of Christine and Ryan, and Brendan was excluded. That Joe Ryan's DNA at the base of the blade, handle juncture, that was the testimony of Leanne Singley and also confirmed by the Division of Forensic Science. That Ryan had a puncture to the left thumb, that was Leanne Singley's testimony, as well as the medical examiner, Dr. Kessler, confirmed that. It was consistent with the knife, Dr. Kessler said, and it was consistent with the self-wounding that happens in situations involving stabbings. And you heard Leanne Singley touch on that. She was able to kind of give you a more circumspect view of what self-wounding was. I think Ms. Groff talked about slicing, fingers or it's sliding or something like that. What we were looking for, and what I think Leanne Singley was able to tell you, is that there are a wide variety of injuries that occur, but oftentimes the stabber is someone that's injured. And I think there were significant statistics that she talked about, which I won't try. You'll have to rely on your recollections regarding that. You saw on the body cam footage, as well as through Ms. Singley's testimony, that Brendan does not have any injuries on his hands. And Ms. Dolly's testimony indicates Ryan's right hand closed when blood was deposited on it. That's consistent with Ryan holding the knife when stabbing, causing blood stains. Joe Ryan, there's a lot to be said, and I think you've already seen pictures of it in this closing, of the 4 stains on Ryan's forearm. What hasn't been said is that they were not tested. Leanne Singley says they're not able to be classified. Ms. Groff disagrees, saying that they are drip stains. She needs to say they're drip stains, which Leanne Singley says you can't say because you don't know the position of the arm, you don't know where it was at the time the blood came out. It could have been something from a significant bleeder as he's standing up. It could have been from numerous other possibilities. But Ms. Groff classifies something that Ms. Singley says you can't classify without certain factors, suggesting that it's falling from above and has Ryan on the floor. One might think you'd find the source of whatever that blood is if you're to have tested the blood that's in question. That might give you a little more guidance. And I think that's one of the reasons Leanne Singley was unable to identify that. If it was from Joe, then she'd probably have some explanation for that as an expert. If it was from anyone else, that perhaps could be a different explanation. But now all we deal with are possibilities. And that seems to be the crux of how the Commonwealth is pursuing this case. They're not putting on any evidence in terms of their own investigators. They're not providing any concrete evidence as to what happened that day. And interestingly enough, the shift in the last closing argument was that I hadn't been doing that. And the defense hadn't been doing that. But I think we can all agree that we've called significantly greater number of police witnesses because we had to. Because we want the truth out here. I called my client, though he has the absolute right not to come up and testify. And he testified. And the relationship issues with Juliana Perez Magalhaes are touchy, and they're an awful story. But he sat there and he answered the questions. He was cross-examined. He answered those questions. We're bringing you the truth. We're trying in every way to get the truth. And many of the Fairfax County detectives have provided that, and that goes to their integrity. The genes, the touch DNA from the waistband zipper indicate Joe Ryan and Christine Banfield are the contributors. Brendan Banfield is excluded. All samples collected and tested on Ryan were from Joe Ryan or Christine. Brendan not identified as a contributor in any of them. Nothing in the materials reviewed gave any indication that Ryan was not the stabber. That was Leanne Singley's testimony. Brendan's jacket, blood on the rear of the right sleeve, DNA on exterior of right sleeve, mix of Ryan and Christine. Brendan indicates that Ryan grabbed his arm on Officer Beckner's video, Officer Baumler's video, in the ambulance, and also in the hospital. Brendan's jeans. The small stains on the thigh is consistent with cast off from the hands. That's Miss Dolly, Miss Groff. Brendan sat in the bathroom, if you look on the video, and the first responders arrived. He was basically told to sit on the tub, and you see him when you look at that video, and he's sitting there, and he's just, hands down, not sure where his hands go, and he was watching as his wife was being tended to. The stains on Brendan's jeans are consistent with him kneeling at Christine giving aid. That's what the body cam video shows. Back to the digital forensics for a moment. February 19th was a critical day because that was the beginning of the Telegram account. Juliana says she watched Brendan. They stole the laptop and the phone. They deleted the two-factor authentication code, but the two-factor authentication code remains on the phone to this day. And this is Defense Exhibit 156. Is it possible that Brendan and Juliana did this without Christine knowing that a Telegram account was opened in her name? It's not, based upon this exhibit. Because if you look at it, and you can look at the message from Telegram, shows up right underneath a message from Brad of Innova PICU, and right above a message from Nicole at Innova PICU. It was done early in the morning. If it had been done by someone other than herself, as soon as she looks at that message from Nicole, she'd realize something's going on. I should check this out. Inconsistent with catfishing and consistent with someone pursuing a fantasy. February 23rd, we saw digital forensics evidence from the evening of February 23rd. We saw use of Christine's laptop for 90 minutes for resort searches, with a couple of minutes of Telegram use interspersed. The Commonwealth in cross-examination opined, well, wouldn't it be possible that even if you were sitting in the same room, that she could have gone away to go to the bathroom for 2 minutes? And I guess, in this world, anything's possible. Is it probable, however? And that's really the more germane point to this. The Commonwealth's, I guess, concern in cross-examination was confirmed, at least in terms of the room, when Brendan testified. And if you recall his discussion, we were talking about, we were already going on a cruise, and we were talking about going to the Dominican Republic. We saw the calendar that showed the place, Royalton Resorts. We showed the searches that showed kid-friendly vacations. So we knew who was behind the keyboard, and Brendan knew who was behind the keyboard because he was there with Christine. And they were collaborating on the vacation research. Brendan was playing with Valerie and Christine was on the couch with her laptop and her phone. That's the testimony. The device's symmetry and connectivity you heard about has the context to complete the entire picture. Juliana was not in the room, and this is supported by the analysis on her phone, showing a steady stream of messaging, social media use, and Netflix at the same time that Telegram, FetLife, and the suspect Gmail account were being used by Christine. And finally, February 24th, Juliana was not awake, not out of bed, based on her devices at the time she claimed to be watching Brendan Banfield sending messages in the kitchen. You heard Mr. Lidsky talk about her Apple Watch. You heard him talk about her phone. We're showing when steps were showing, which would be an indication of someone moving. She had not moved for some time after the laptop was accessed. What we know from the testimony yesterday was that Christine Banfield had the laptop and the phone in her bedroom and was awake when he went up to retrieve Valerie. That is an artifact in the world of digital forensic analysis. And you'll see this entire exchange, Defense Exhibit 348, 349, 350. You'll see Juliana Perez Magalhaes' first steps at 626. Defense Exhibit 351, 352, and 353. Juliana Perez starts her day after the telegram message is already sent, in conflict with what she's told, in conflict with the story that she's adopted on behalf of the Commonwealth. Brendan's at McDonald's. Exhibit 354, 355, 356. Those are timestamped screenshots from the McDonald's videos. Juliana is on the phone telling us her phone tells us that her activity stops at 7:24 under Defense Exhibit 357. At the exact same time, her watch steps are stopping at 7:24. Defense Exhibit number 358. Defense Exhibit 359, Juliana steps resuming on the phone at 7:41. Exhibit 360, Juliana, car is parked at 7:41. Exhibit 361, Juliana's watch resuming steps at 7:42. We know that Brendan was out of the house. We know that Juliana was in her car. And if you look at Exhibit 362, there's someone who's logging into Christine's laptop at 7:33. There are no other humans in the house. And Juliana and Brendan were not there. In conflict with the government's theory, Christine logs into her laptop and places her devices in a drawer. She puts the devices away. She gets Lily down into the basement, brings her food to the basement, and gates her in. And she meets Joe Ryan. And they walk up to the master bedroom. Why? Why would Joe Ryan stab Christine? If you take away the consensual part of this, if he were found in a bedroom of someone by someone who's a police officer, he'd be looking at a life sentence. In this instance, he was confronted by an armed law enforcement officer saying police. That officer was standing in the only way to get out of that room, other than jumping through the window and falling down 3 flights. He had a gun trained on him, and he was telling him and was told that he was going to be arrested. He had marijuana in his system, and he was angry. Who was he angry at? Could he have been angry at Christine, thinking that she set him up? Could he have been angry at his situation for deciding to go into a house that he didn't know and put himself in this situation? Could he be angry at my client, who was there to try to figure out what was going on and ultimately try to protect his wife? Those are the whys. And if we'd had any investigators that were actually involved in the case coming to the stand, those would be questions that I would want to know, and there would be questions that you would want to know. Because you have a decision before you, and that decision requires a review of all of the evidence. Now, is it reasonable after a 6 to 8 week affair that someone's going to try to get rid of their companion of 19 years, wife of 12 years? Is that reasonable? You heard from my client, he thinks it's absurd. In pursuing this case, the Commonwealth has presented absolutely no forensics evidence that supports that Brendan Banfield had anything to do with this, yet the story continues. This isn't how justice works, and you can't just come up with a theory and make it fit. They're trying to sell you a story without any facts. And we have the facts, and those facts are in evidence. Those jury instructions, when you see them, you'll realize they're very clear. If you have doubts about the investigation, if you have doubts about how they've conducted this investigation, if you believe that there's something that's been held back in this investigation, that's reasonable doubt. That's reasonable doubt before you even get into the things that negate the possibilities of their case. And these are hard decisions. There's a lot on the line. But know this, if they fell short in what you expect should be the investigation, if they fell short, that's not on you. The jury instructions say you must acquit. And it's not on you. I don't have another opportunity to talk to you. It's their burden to prove this beyond a reasonable doubt, so they get the opportunity to speak. So I apologize if I've gone too long, but I wanted to make sure that these important issues came before you. And might leave you with these words. When they lie and manipulate to get someone to make a statement, that's not discovering the truth. That's planting the truth. Ladies and gentlemen, thank you for your attention. Thank you for your patience. And at the end of your deliberations, I ask that you find my client not guilty of all charges. Thank you.
All right. Rebuttal argument. Switch over the mic again, Mr. Carroll.
Thanks. All right, just a couple of last words. Mr. Carroll has a really interesting recollection of the evidence. It certainly doesn't match ours, and I'm guessing it doesn't match yours. FYI, the lab for the coat was 165, not 167. And the DLI lab, it doesn't say anywhere on it that it was touch DNA. It was blood that they tested. Juliana did not repeatedly say that she didn't know how to work Gmail. She said that she did not create the Gmail account, that was Brendan. Giaccio and Bruce had the catfish plan and they peddled it and pushed it to everyone. I don't think that's at all what came out. I think that Mr. Carroll is trying to focus on the HR woes of the Fairfax County Police Department to distract you from the fact that the evidence actually supported that theory and that he has provided you and his client has provided you with absolutely nothing to refute that theory. Why was there so much discussion and disagreement over the digital evidence? Because it could never be that smoking gun. You all heard it from their expert. You can't put someone behind that screen unless you're sitting next to them. So as much as we want it to tell the story here, as much as we want it to be the perfect evidence that proves beyond a reasonable doubt that this thing had to happen, the digital evidence just isn't that. We wish it were, but it's not. And Detective Miller did nothing wrong, and Mr. Lidsky did nothing wrong. They just told you the truth. And the truth is that they can tell you what a device was doing, but they can't tell you who was using the device. Juliana Perez Magalhaes' testimony was bought and paid for. Yes, she pled guilty to a lesser offense in exchange for her testimony. Ms. Frissler made sure you knew that from the get-go. Juliana talked about that. She explained for her reasons why. Nothing was hidden. After her sentence, it sounds like she might have the opportunity to make, 10 grand off of selling her story. She said that she would use that to support her family. And then what? Is she gonna work as a nanny? I mean, she's a convicted murderer. Do we really think that it is so reasonable that she made up this complete lie for 10 grand? Really? If this version is correct, coming from Mr. Banfield, then she would be set free. She would be as not guilty as he would be. So she's going to give up that shot for 10 grand? I just don't buy it. Whose story is more credible here? Juliana's or Mr. Banfield's? Whose version does the rest of the evidence support?
Members of the jury, this is an important case to both the Commonwealth and the defendant. In order to reach a verdict, each of you must agree on that verdict. In other words, the verdict must be unanimous. The first thing you should do when you get back to the jury room is to select a presiding juror. The role of the presiding juror is to see to it that the deliberations are conducted in an orderly and businesslike manner, that they are conducted only in the jury room when all members of the jury are present, and that each juror has the opportunity to fully and fairly express his or her views. It is rarely helpful for jurors upon first entering the jury room to take a straw vote, or for any juror to make an emphatic expression of his or her opinion in the case, or to announce a determination to stand for a certain verdict. To do so before all jurors have had an opportunity to consult with one another and exchange views and opinions might allow your sense of pride to prevent you from retreating from an announced position, even when shown that such position is unsound. You have a duty to consult with one another and to deliberate with the objective of reaching an agreement, if it can be done without offending your individual judgment. Each of you must decide this case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. In the course of deliberation, a juror should not hesitate to re-examine his or her own views and change his or her opinion if convinced it is an error. However, none of you should surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. In the jury room, you will have the exhibits that were entered into evidence. You will have the instructions of law that I just read to you, and you will have the verdict forms. Much of the evidence in this case was in electronic files, so you're going to have a clean laptop that's going to have those files on there for you, and that you will be able to access. And you also have the big TV in the jury room that you can plug in the laptop to that so everybody can view the evidence at the same time, okay? As far as the firearms and knife, the Sheriff's Department has control of those items. If and when you want to see those items, you just have to let the deputy know, and those items will be brought to you. Only the deputy will handle them, but you can ask her to manipulate them however you wish to have them manipulated. But please do not have any deliberations while the deputy is in the room with you, okay? Wait till the deputy leaves before you do that, okay? All right, so during your deliberations until you are discharged from jury service, you must not communicate with or provide any information to anyone who is not a member of this jury by any means about this case. You may not use any electronic device or media to conduct any independent research about this case, the legal or factual issues in the case, or the individuals or attorneys involved in the case. You are not permitted to consult dictionaries or reference materials, search the internet, visit websites or blogs, or use any other tool to obtain information about this case to help you decide the case. Do not try to find out information from any source outside the testimony and the exhibits received as evidence during the trial. You will have, again, you also have with you the verdict forms. There's 4 charges in front of you, okay? So you're going to have 4 separate verdict forms, all right? Once you have decided, have made a decision, each of the verdict forms should have the 4-person signature at the appropriate place. There's places for guilty and not guilty for each count that you've heard: 2 aggravated murder counts, 1 firearm count, and 1 child endangerment count. Okay, so each form is separately. So each form, upon the finishing of your deliberation, should have the signature of the 4-person just on 1 space on each form. Okay, if you sign both places on the form, it gets confused. If we're confused, then that's not the way it works. Okay, so just make sure you do that. Okay, now for the last part before you deliberate, the fun part. You remember that in the beginning of this case, I told you we had randomly selected 4 people to be alternates, okay? We still have 4 alternates. Thank you all for your service and being so professional, and even during the snowstorm, making here on time, and we do appreciate that. And let me just say before I release the alternates that I know that this trial has been a huge sacrifice for you all and have taken you away from your lives for 3 weeks now. I know I speak for all of us associated with this case that I want to thank you for your service in this matter. I know it is hard to have come this far and then not get a chance to deliberate, but that does not lessen the respect and admiration that we have for you. As an alternate, you will not deliberate, but you will still be under the order of the court, okay? And so you cannot do any outside research at this time in the case, or you can't talk to anybody about this case at this time because you're still under oath as a juror. That is because if something happens to a juror during deliberations, I will call you back to service and deliberations would start again as you would be part of the jury as well. So that's why you're still under the order of the court. You are under these restrictions and your oath until a verdict is reached. Once a verdict is reached, we will reach out to you and contact you and let you know this has occurred, and then you are free from all your obligations, okay? So again, thank you for your service. At this time, I'll call the alternate jurors, and if you could go with the deputy, we have to collect your items and we'll get you on your way, okay? So the alternate jurors I have are number 26, number 24, and number 38. So if you could follow Deputy Johnson out at this time. 26, 17, 24, and 38. 1, 2, 3, 4. Okay, so ladies and gentlemen, these are the 12 jurors that are going to be deliberating in this case, okay? You can take as long as you need to deliberate, and at this point, you can take breaks whenever you wish to, and you can let the court know. If you're still deliberating next week, you can let the court know if you want to come in at 9, you can come in at 9, or if you want to come in at 10, that's fine. When you're done for the evening, I know there's one juror that has to be done by 4:30 today, so make sure we respect that timing for that juror. But you can take breaks whenever you wish. You can take your lunch breaks and you can make them an hour, you can make them a half hour, you can do what you like. It's just important that you do not deliberate at any time unless all jurors are in that jury room at the same time, okay? So during breaks, we don't deliberate, okay? We make sure we take care of that. All right, do we have another deputy that can? All right, I can excuse you now to deliberate at this time if I have a deputy.
Judge, while we're waiting on that moment, can we approach on one?
Sure. Gentlemen, just one more item before you deliver. If for some reason you have any issues with the laptop, please let the deputy know. And if you're having trouble with any of the exhibits, let us know because we can print out anything and everything that you need, okay? So if it gets frustrating at any point, just let me know and I'll make the parties print anything out that you need, okay? All right, thank you. You can now go to deliberate. All right. If you want to review the verdict forms before they go back as well, the laptop is coming from IT, so if you want to wait for that too for me, so just so you can make sure the laptop is clean and everything, all your exhibits are on there, and then that will go back to the jurors, okay? All right, we'll be in recess then.
All rise.
All right, so the court just went into recess. The jurors are now officially deliberating. The time is 12:35, and the jurors now have the final decision on what will be the fate of Brendan Banfield. Thank you so much for staying with us. I know a lot of you have been tuning in both on WUSA 9 Plus and on YouTube. I'm Katie Lasso. This is Frank Salvedo, criminal defense attorney. He's going to be answering a lot of questions for you guys, and I see them pouring in, so we appreciate you sending them our way. If you do have a question you'd like Frank to answer, I know this has been a lot, you could text us at 202-895-5599. If we could put that number up on the screen in big letters for everyone. 202 is the number, 895-5599. Again, just text us and we will try to get to those questions as quickly as we can. So just a quick recap of what has happened in the last few minutes or so. So we saw today the prosecution, they did their closing arguments, then the defense did their closing arguments, the prosecution did a rebuttal, and then we heard instructions being given to the jurors. We found out that the 4 alternates for the jury were still in the room. They are now sort of clear. They still have to be on standby in case anything happens. And they are going into deliberations right now. They'll be doing that until 4:30 tonight. And then, let's start off with a question here, Frank. Somebody asked if the jurors, if they don't reach a verdict by 4:30 p.m., what happens? Do they deliberate over the weekend, or are they only deliberating during working hours, if you will?
They're only deliberating over working hours.
Okay.
The jury right now sets the schedule. It used to be the judge kind of in control.
Mm-hmm.
Now the jury is completely in control. So you saw the judge at the end say, the schedule of your deliberations is really up to you.
Mm-hmm.
They may decide to come in early if they haven't reached a verdict by today. They may come in early Monday. They might come in later. They might go from 10 to 6. The schedule is really up to them. And that includes when to take breaks, when to go to lunch, etc. Now, if even one juror steps out of the deliberation room to go to the bathroom or get a snack or something like that, all deliberations have to stop. They have to all be in the room, all 12 at all times during the deliberations. So their schedule is kind of up to them, but they all have to be together.
Yes.
True crime just got darker. Catch the full episode on the link above. Subscribe to At Southern Sin today and hit the notification bell for more live original episodes Wednesdays at 8 p.m.